My lord, may I permit to mention for inclusion in the list, my lord. Petitioner is the railway subscription allowance not getting any financial hardship, my lord. Logically inclusion in the list, my lord.
Motion.
Motion, yes.
It has not been heard earlier.
My,
Earlier it was not heard.
no, my lord. 2017, my lord. Railway is the employee, my lord.
My lord, this is the matter by order dated 12th May 2026. This particular court number 1, my lord. It was scheduled to appear in the July, my lord. But it is a question of livelihood, my lord. Please consider to list the matter.
The next monthly list.
My lord.
It will be in the next monthly list.
First monthly list. August monthly.
Where is your notice to the other side?
My lord, because it is in the order sheet, my lord. That's why the question, the notice is necessary because he was present, my lord. I have mentioned the order dated.
Your Lordship, may I be allowed to new motion, Your Lordship?
Pardon?
New motion, Your Lordship, arising out of Central Administrative Tribunal. There are two connected matters. Your Lordship may permit the matters to appear.
You have filed it?
Yes, filed it. Mentioning slip with notice. I've served the notice to the other side. I'm mentioning upon.
May I have your lordship?
All new motions which are being mentioned with notice, please hand over this slip. New motions, whichever you are mentioning with notice, please hand over this slip. All right.
May I have your lordship's kind leave to mention a matter? My lord, this is a WP city where, my lord, the matter was fixed for final hearing. The matter was fixed for final hearing on the last occasion. My lord, the matter was taken up and an interim order was passed. Thereafter, the respondent side took a specific stand that penalty is in currency against me. This pertains to.
What do you want?
My lord, I'm going there, my lord. What has happened is
What do you want?
My lord, the learned tribunal has passed an order of stay. My lord, I want a date, my lord, for early hearing. Only that.
Is it in the list?
No, my lord.
Let it appear in the list.
It will appear in the monthly list of August, my lord. Yes. I'll lose time. That is why I'm praying, my lord.
Mention in the month of August. Let it appear first.
My lord. My lord.
ওটা requisition করে যদি থাকে
signed matter. This matter of Bardwan University, I have hearing of the both sides have completed only state response is
give this.
My lord.
ওটা না
My lord, praying
that assign.
My lord, today is the last day. Otherwise, my lord, it will be time barred, my lord. Praying to file.
Why you have not applied for certificate?
Applied for certified copy, but till date, my lord, no certificate.
When was the order passed?
Order passed on 16th June.
16 June. When did you apply for certified copy?
3 to 4 days after, my lord.
Where is your application? You don't know when it was applied.
No, my lord, it is today. Clerk has not come.
Process, sir.
My lord,
get the certified copy, file it.
My lord, it will be time barred, my lord.
How it can be time barred? You will explain that we have made a certified copy application. You will come. Yes.
My lord, may be permitted to mention for upgradation, my lord, item number 387.
Upgradation not now. Is it in the list?
Yes, my lord, it's in the
Remind
list.
us when we take up August monthly list. Yes.
My lord, may for inclusion in the list. It's a appeal matter. Your lordship heard the matter on last of 8/6/26. It was supposed to appear in the list, but
Please, my lords. Because these are two PIL matters. These are two PIL matters, my lord. Affidavits have been exchanged between both the parties.
Then
On 7th of this month, your lordships were pleased to allow my mentioning and thereby listed. However, subsequently thereafter, the monthly list came and my matters were listed at 422 and 423. I'm only seeking upgradation for final hearing.
Mention in August, let us.
Lordship, may I be permitted for one mention?
No need of upgradation because we are taking matters from the combined list in this year in the supplementary
That's
list.
my only predicament.
So keep a watch on the list. Please appear when the matter is called. Yes.
Lordship, may I be permitted for one mentioning for upgradation? One PIL matter.
Upgradation not now. Mention in August. Yes.
No more to public interest litigation.
Pardon?
quo motu public interest litigation is in there, according to the direction of the Supreme Court, which is appearing as item number 355 of the month list. The matter was heard prior to the vacation.
Remind us in August if it is not reached. Yes.
My lord, mentioning for withdrawal, my lord.
Huh?
For withdrawal, my lord.
Yes, to be mentioned.
Lordship, mentioning for inclusion, this matter had last appeared in the list of erstwhile Chief Justice Sujay Paul. This is a WPCT matter, and we have some urgency, Your Lordship.
Give the slip, it will be in the combined list.
My lord,
185.
may I be permitted to mention a tribunal hearing of 2013, my lord? My lord, tribunal hearing of 2013, lordship. It was made returnable in the month of July, my lord. It did not appear in the list. Deeply
Give the
obliged.
slip. Hey, August diye diyo sab. Just
May I, my lord, have your lordship's kind leave to mention item 24? I am for the petitioners, my lord. I have not been able to come to court due to a slip disc, my lord. I am only praying that this matter not be taken up this week. Any day, I have spoken to, my lord, I have spoken to the other side, Mr. Chirodev Sinha. And the joint prayer is if your lordships can kindly take up the matter on any date except Monday next week. I would be very grateful. I apologize for mentioning online, my lord.
item 24.
Yes, my lord.
Not this week could record. Yes.
My lord, one is for correction and
Let me
another
know.
is for dismissal. It was appeared and directed for the service to the parties. I have made the service. It was directed to appear on 29th June, but not appeared. Kindly for listing, praying. 29th June. After that, the bench is changed.
Pass the order.
Previous, my Honorable Chief Justice order.
That is a motion.
Yes, my lord. Motion one is for correction, disposal. Then I have made a correction.
One by one. Give the slip for correction.
Yes.
Correction, what do you want?
Correction, other party was appeared and the name was wrongly. Two corrections.
To be mentioned. Yes, another.
And another is one appeal was filed by me, police in action. On that day, 498 case was remaining in the lower court. That is why I am not able to appear. And that then direction passed for dismissal and fixed the date on 29th June and pray for service. I have made the service, but that not appeared.
Dismissal of what?
Dismissed as I not appeared. That is why fixed for dismissal.
Dismissed for default.
Dismissed for default by notice, not dismissed. But Bangla
দেখে নাও
grateful man.
মোশন থাকলে লিস্টে দিয়ে দিও yes call the list.
I'm appearing for the appellant, Your Lordship.
Yes,
This
you have
is
got
the
petition?
matter where, yes, we have filed the wakalatnama, and this is the case status where it is indicating the change of the advocate. Along with that,
Letter is there. You
Sorry?
brought the letter.
Yes, this is the direction of the client.
দাও এই নিয়ে নাও
লিখে দিন appealing for the appellant. Submit that
last occasion, your lordship was pleased to direct for the demolition.
Yes, my
of
lord,
two
demolition.
guest houses in Turkey. Demolition was conducted by my instruction is, my lord. This was not a complete demolition. So partial demolition took place.
85% demolition completed, 25.
Let the report be called.
Yes, my lord. I have the report with my WhatsApp, my lord.
And
you make it possible, my lord. I will, within 5 minutes, I will give it.
Mr. Chatterjee does not believe in WhatsApp. What can you do?
My lord.
You have to give copy to Mr. Chatterjee.
Well,
কি আলাদা করে কপি দিয়ে দেবো না ছবি দেবো
ছবিতে হবে না তো, চোখে দেখতে হবে তো।
যা
কোনো
চলছে
মাথায় গোল গোল করে ভেঙে দিয়ে
What is your case? It is being demolished?
Yes, partially demolished, my cases.
My lord, I am for the private respondents.
85% demolition
Being demolished.
complete.
So what, demolished or not demolished?
Partially demolished, my lord, as they have.
Partially
said.
demolished.
Partially.
So,
But I will-
majority,
I will
Being
try, my lord.
demolished.
I'd like to file an evidentiary proposition because there are certain discrepancies.
so why partially?
No, you have nothing to do, sir. If you are aggrieved by that, you should take appropriate steps. And this matter was mentioned again, somebody else mentioned.
My lord, false incorrect submissions and also saying that the demolition is being done is an order of the court. My lord, I have because to show. And there is no sanction plan. It was all submitted. It is the last order sheet. It will reflect it. It will be reflected.
Mr. Chatterjee, we dispose of the matter.
Just
Demolition is going on.
Lordship, my lord,
Record is submission that it has been partially, major portion demolished, remaining portion
Lordship,
should be
kindly
demolished.
keep it pending so that municipality should come up with a report saying that it is completely demolished, my lord. Otherwise, my
Did
lord,
we call for any report?
My lordship has called for the report, my lord. I come with, my lord, they have sent me in WhatsApp, my lord. My lord, they will come, my lord, give me 1 day time, they will come.
Status
My lord,
report, yes.
my lord, demolition process is going on, till that is going on. My lord, this is a huge unauthorized construction without having any sanction plan. I have fairly submitted.
This without any sanction plan.
Yes, yes.
That's a false submission, my lord. Your lordship will kindly cease.
Next
There are
Friday.
plan, my lord.
Next Friday.
My lord, should I get an opportunity to very short period, my lord?
283 is there.
We will hear you on Friday.
Within 1 week, my lord? Within 1 week?
Yes, it will appear
Titan
next
in that.
Friday under the same.
affidavit.
I shall come up with an evidentiary
My lord, I give the affidavit of service where I have communicated the last order passed by your lord.
Affidavit of service, comma, as filed, comma,
এক মিনিট।
Report is say.
Your lordship, Your lordship, Mr. Bhattacharya, learned advocate, additional advocate general is appearing on behalf of KMC. Due to some difficulty, as he is having puja of Lord Jagannath at his home, he could not reach today, your lordship. Praying for an accommodation of the day only, my lord.
But do I
My
say?
lord, may I submit? Mr. Villodhal Bhattacharya is appearing for KMC, my lord, and he is the answering respondent in this matter, my lord.
No, state has also to prepare. State.
But he is the main answering respondent. We are on the same footing, my lord. We are on the same footing. We have taken instruction, my lord.
But this is a case where the heritage property should be protected. This is historical duty. Well, let us
We
see.
have
what-
taken instruction, my lord. KMC will answer to this, my lord.
Let it be on the next week, Monday or Tuesday, subject to court's convenience.
Any day, my lord. Subject to
my
Not
lord.
on 20th, sorry, 20th and 3rd.
আপনি দেখে নিন স্যার যেদিন থাকবে সেদিন।
20 আর 23 বাদ দিয়ে।
To be mentioned 27th.
27th, my lord. Grateful, my lord.
But they should come ready with the report, Lord. Kindly, otherwise they will again say
Direction is there.
that was there, but no, so for the state is concerned, they have also come. They only sought time for, my lord, the instruction.
Instruction, sir. KMC's instruction will suffice, my lord. We have taken instruction on that, my lord. KMC is dealing with the issue, my lord. If
All
that,
right.
we will put that on instruction. my
Let
lord.
them come and say, Mr. Bhattacharya.
If that be so, my lord, we will put a.
If you have prepared, so give a copy to Mr.
Yes, yes, my lord. I will certainly. I will. Grateful, my lord.
Lord, I appear for the appellant. My lord, the
I am for the
the
contempt.
SLP was taken up. My lord, the Honorable Supreme Court was so surprised with the audacity of the university. Not only
But
this,
ultimately, what order passed?
ultimately, not only SLP dismissed, the Honorable Supreme Court, I myself appeared. Initially, it was not known. Kindly have a look at the order.
Now tell us now what happened.
My lord, I said that, my lord, as exactly I said before your lordships. There are situations are different. Here, there was a particular date. Rightly, wrongly, the division bench passed the interim order. They can, of course, file an SLP. And they know if they don't comply with, they cannot think like my SLP will be allowed, because this is kind of the examination cannot be. The honorable, the bench was so furious. They said you must face, and that's why that my submissions were recorded in paragraph 2.
You have given.
I am appear for the contempt, my lord.
So how the bench said, how can you do so? Now they cannot even take the even point of SLP being filed also. That was also clarified. Paragraph 2. This petition, the last sentence, the petition will be decided. That petition means this contempt on its own merit, uninfluenced by any of the observations therein.
I am appear for the contempt. I have fulfilled the all the order.
Fulfill the.
My lord's order was already complied.
Let us not, I think, my lord, there has to be, line has to be drawn.
My lord,
I think I can,
30
my lord, the
students.
law
Let me finish-
officers.
let me finish first.
I know what you'd be saying. That's a different thing.
30 students were given registration number.
This
is
kind
the
of things
chart.
can only happen, my lord, when they
And
get a
another
completely
date was
incorrect
fixed.
legal opinion.
May I finish?
So you are holding exams for them?
Yes, yes, already there.
Provisional registration have you granted?
Already given, my lord. Registration.
My lord, they have.
So then it becomes an ego fight.
My lord?
It becomes an ego fight.
No
You
ego fight.
wanted to see whether the students go up and contest your SLP or not. This conduct is deprecable, especially when it is a principle of an
I
institution.
cannot say, my lord, something, my lord, in court.
You have nothing to say, sir.
So many students are coming.
That is not that should not be the.
Anyway, we are
That
giving.
is not our concern. You are running a
Apology, my lord.
university.
We are apology. We are seeking apology. We have complied all the direction made by you.
Who knows? 17th is the date. Again, you can go up to Supreme Court with some other issue and come and tell us SLP is pending.
No, SLP is pending.
Don't
Immediately
practice.
we have filed SLP at the date
When
of
was
SLP
the
rejection.
SLP dismissed?
The SLP
10th.
July.
10th.
When did you issue this notice?
10th.
Well,
On the 10th, issue notice.
Well, this will not be the same examinations.
On the
3,050
same date, my
candidates
lord.
appeared in one examinations in one question paper.
On the same date, we issued.
They need to answer their conduct. The apology cannot be the verbal.
এখন order comply with, we will not within the time. Not within.
And registration is already given to all the students.
There.
Well,
When have you scheduled the exam?
Pardon?
When have you scheduled the exam?
21st and 23.
well, they said that on 21st, only for these students, they will hold an examination.
Only for these students.
Who filed this petition?
My lord?
Who have filed this petition?
Yes, yes.
Who will file this? 30 students.
Such benefits shall not be given to similar situated.
No other students came before us.
No, no. It is natural. It is only for
Other students are already.
Now, where is the date of the exam?
exam is over. That's I'm saying. The
Now, this
violation,
examination.
the examination was on 30th. That was that is gone.
21st, my
Now they are saying because they have to hold two examinations, two papers.
21st and
21st and
21st and 23rd. Well, let them hold the examinations, of course, because I have to. There are the twin parts, but they must explain this. The apology and everything must come, my lord, in writing. I say this not for my clients, so that even my learned friends also understand and realize there is a borderline. While advising to file an SLP for such cases,
On the same day, my lord. SLP was rejected on 10th.
No other option now.
My lord.
You have to give.
My lord.
They are not at your beg and command.
No.
You are treating the students like that. That you come, put your head on my foot, then I will consider. This attitude is not proper, especially of an educational institution. You better apprise your client. You are not apprising your client in the appropriate manner. On the contrary, you are advising that let us fight it out. After it, we will comply. This schedule, it appears from the letter, this was already prepared by you. And your principal said, let the SLP be dismissed, I will sign the order. This conduct is not proper, especially of a head of a university. That is due to the instructions you give, without considering that first you are the officer of this court. You instruct your client, all right, let us see, we will defend you in contempt.
No, my lord.
Exactly. This letter was already drafted by you.
No, my lord.
And you said to the principal, don't sign it, sir, because SLP is there today.
The law department is there, my lord.
Who?
They guided. Law department is there, university.
Law department.
Why should I instruct, my lord?
Huh?
Why should I instruct?
That is, we are surprised. Why? And if you have not, if that is your not instruction, then how your controller of examination signed it immediately on 10th of July, on the date of dismissal of the SLP? So this was earlier prepared. Program was made. Everything was chalked out. Let the Supreme Court dismiss it. We will publish this. But sir, we were not going to leave you. You need to be taught a lesson. And we will make appropriate comments to that effect. We will give you an opportunity of hearing. But prima facie, your conduct, this way an institution does not work.
I will be excused, my lord.
Where is your flamboyant advocate who was arguing? Who was arguing? Mr. Chaudhuri, where is he?
Perhaps he's
outside the courtroom.
No, my lord.
My lord,
Oh, he's gone
my lord, I
online.
am appearing.
Rajarhat.
My lord, I beg to appear virtually, my lord.
He's not in the High
My
Court.
lord.
Senior advocate appearing for the applicants stroke petitions submits that the special leave petition preferred by the West Bengal University of Health Sciences records reveal that when the contempt application came up for hearing on 8 July 2026, it was submitted on behalf of the Mr. Dhar Learned Senior Advocate appearing for the petitioner submits that in spite of full knowledge of the order dated 25th June 2026 passed by this court, the alleged contemners did not grant provisional registration and did not allow the students to participate in the examination. Stop. On behalf of the university, it was submitted that they have preferred a SLP before the Honorable Supreme Court, and the same was returnable for hearing on 10th June 2026. 10th July 2026. In view of such submissions, the contempt application was adjourned. Today, Mr. Dhar submits that upon contested hearing, the special leave petition preferred by the university was dismissed by the Honorable Supreme Court. Stop. The alleged contemners have thus dismissed by the stop. Mr. Maiti Learned Advocate appearing for the university has
Contemner.
for the
Alleged contemner.
for the alleged contemners submits that immediately after the SLP was dismissed, the controller of exam controller is a contemptor.
Not party, my lord.
Is a
Controller is also
the immediately after the SLP was dismissed, the controller of examinations bracket A in charge bracket close of the university had issued a notice. The provisional registration public issued a notice detailing the schedule of the examination that would be held for the petitioners. For the petitioners. Stop. Answering our query, he submits that as per the order of this court, provisional registration has also been granted. Let the notice, comma, as placed, comma, be kept on record. From the next paragraph, from the said notice, it appears that the exams, the dates of examinations have been fixed on 21st July and 23rd July 2026. Mere pendency of a SLP, mere pendency for mere pendency of a special leave petition, the alleged contemners could not have, ought not to have acted contrary to the directions contained in the order dated 26th June.
25th.
20. Prima facie it thus appears that the alleged contemners have violated the order of this court. In view thereof, the alleged contemners are directed to file an affidavit in opposition, explaining as to why they did not comply with the order of this court within the period as specified. Stop. Let such affidavit in opposition be filed. 23rd July. Let such affidavit in opposition be filed by 30th July. Reply thereto, Penny, be filed by 6th August. Is the matter for further consideration in the daily supplementary list of this court on 11th August.
My lord, only one. This is, I request my learned friend, because these examinations which they would be holding, I'm accepting because I don't have a choice. I would expect that which the standard which they did for more than 3,000 candidates, it has a one kind of question paper. Now it is only for the few. I would expect, I don't want your lordship to say anything. Don't put a standard be suddenly higher so that they fail that kind of way. I expect that some good sense prevail.
That will not happen.
You should not have that expectation. Let them do what they want to do.
Yes, ma'am.
Court is there.
Deeply obliged.
Which date?
We are grateful, my lord.
And in fact, I should say, my lord,
Take into consideration these facts also.
And in fact, the Honorable Supreme
If
Court.
you have anything personal against the students, that is another thing. That I will see how you get.
No.
Now your conduct shows. We are not saying. Your conduct speaks of your actions. So we will not be surprised if you don't grant pass marks to these candidates by holding the examination.
No, my lord.
Well, now that the matter is
Then
over, my
again
lord,
the advice will go.
You should not.
It is a ego battle. I will not allow. Let us see what happens. Let us see what happens.
4 and 5 same order.
Yes. Yes, same.
ওই separate order আছে নাকি? No, separate.
Both 4 and 5.
Same.
See, Mr. Maiti, it is done. We
No,
are
my
in
lord.
thesis of the matter. You are a responsible person. We are taking. See that everything is done in the manner which the court desired and direct.
in fact, my lord, my clients also, my lord,
I am always for the students.
wanted to prefer an SLP, but my lord, fortunately, I could impress upon them that your lordship has taken care of that. Lordship has, in my lord's order, observed that this participation will not create any equity in favor of the participated. Luckily, my lord, fortunately, I could impress upon them.
There are two contemners.
No, my lord, I am not a contender or the party respondent in
There
the
are
risk.
5 contemners.
Then we are calling for affidavits from alleged contemner number.
Alleged contemner.
Sorry,
You,
4
Mr.
contemners.
Chatterjee, you are
My
not.
lord, I appear for the INC. My
Mr.
lord.
Chatterjee is nowhere
It's not a
here.
contender.
Then who are the university respondents, sir?
Well, they are the Vice Chancellor, the Registrar, Assistant Controller Examination, and the
nursing
Officer in
teacher.
Charge Nursing.
Who
mainly?
Vice Chancellor is not at all responsible man.
He will file an opposition. This is contempt. The alleged contemners, contemner numbers, কত?
1 to 4.
1, 2, 4. 1, 2, 3, 4 আর কি 1, 2, 4 are directed to file independent affidavit in opposition. Replies there to করে দেবে with its
In fact,
1, 2, and 4.
Yes.
2, 3, and 4. 1, 2, and
both 1, 2, and 4 same. In
no, 1, 2, it's English 2, TO. 1, 2, 3, 4.
Oh, the same array of parties in the other contents.
Yes, yes.
Same.
1, 2, 3,
1, 2, 3, 4.
Mr. Maiti, your vice chancellor and everybody has to put in independent affidavits because this is
I
contempt.
filed all of them independently.
I filed for the inventory Vokalatnama today.
Yes, yes.
Malad,
Also, I'm separate Vokalatnama file.
Malad, in fact, I should say this is for consumption of my learned friends. The Honorable Supreme Court even expressed saying, I could have understood how dare you don't allow them to sit in the exam. I could have understood you file an SLP saying we will not go through the examinations because you know exam will be over, you won't be able to do anything. So advise properly your client. That was exactly came very heavily, Justice Vishwanathan. Deeply obliged.
We are grateful, my lord.
ওই ওনার অনলাইন কে কে অ্যাপিয়ার করছে ওদের নাম দিয়ে দিও।
Grateful, my lord.
Yes. Same also.
এই তো ভয় পাচ্ছি না উনি আগে সিক্স প্লিজ ডেকে যাও যদি না আসো।
Well, I am for the respondent.
I'm for the petitioner. Union of India, before Lordship is lead petitioner here. We are challenging two orders of the Central Administrative Tribunal. Firstly, the first order dated 7th March 2024.
Emotional state. Any interim order.
Any interim order?
No, no interim order.
That's
But
for passing any interim order.
No, my lord. Only thing, direction was given upon the department concerned, the Ministry of Defense. There is a the department is Ordnance Factory Board to provide certain financial benefits. That is in consequences which arises. That during the period when he was not working, so no work, no pay. The principle we have followed, but tribunal directed since deliberately he was. The situation is deliberately is a transfer order which was under challenge. He deliberately did not avoid the place of posting. Therefore, you are supposed to pay him all consequential benefits. During the period he was absent. So we are agreed only that part of the order. But the transfer order was issued in 2021, on 2022, 11th April. It's very short. Facts are very short. We are only agreed with that portions of the order. Transfer, he didn't join in the transfer place of postings. Rather, other employees in a common order where the transfer order has been passed, the other employee had joined from Kolkata to Delhi in the transfer place of posting, excepting this respondent. Subsequently, considering
transfer order was stayed by the tribunal.
But that has to be interpreted. That has to be interpreted by us.
They did not allow
it was stayed, but the fact remains. Prior to that, the release order was issued, which we brought it to the notice of the learned tribunal. Release transfer order as well as release order was issued on 11th April 2022. 11th April 2022 on the same date. And this order of stay was granted on 9th September 2022.
Now your contention is that since release order has not been challenged or has not been stayed.
Release order has not been stayed at the point of time, but subsequently it was stayed. In the meantime, release order was issued. In a common transfer order, 3 employees were transferred from Kolkata office to Delhi in terms of the policy of the department, the government.
How you have implemented the interim order?
So interim order, which was passed, that was for limited purpose, limited period, that is till the filing of a reply affidavit. That is within 4 weeks, direction was given upon the department to file reply to the OA applications within 4 weeks. Till such time, interim order will be effective. But prior to that,
you did not challenge that interim order.
Interim order, my lord, we didn't challenge.
If you
That is
would
the
have
point, my
challenged,
lord, I
you
found.
have taken this point. If you had challenged, then you could have taken this point, Mr. Nandi.
But fact remains, my humble submissions today, my lord, if a person or employee, my lord, did not work during a particular period
for your action.
No, my lord, we have not as a whole, because
No,
that's a policy, it's a guideline.
That is the thinking of the tribunal.
Right.
That had our interim order been complied with, there would not have any occasion for the petitioners not to work. Your contention is we passed the release order on the self-same date.
Lordship.
Whether you brought it to the notice of the tribunal or not, that is not our concern. But Mr. Nandi, the thing is that you did not challenge that interim order.
I appreciate your lordship. That is the point.
So, now, just give you, what is the implication? Having not challenged an interim order, can I violate the interim order?
This is, my lord, that was the, my lord, I think so, my lord, my humble submissions in response to this, my lord. The department brought it to the notice.
The tribunal has directed to give financial benefit for which period? 11th
From the
April?
date of interim
11th
order
of April.
passed,
And
9 September 2022
till
date of joining.
Till disposal of his
Yes, date of
representation.
joining 2nd May 2024. During this period,
You did not give the actual salary. Spent now from the 9th September
9 September 2020
and the date of disposal of his representation as having spent on duty. Where is that order? Disposal of that representation
yes,
as spent on
yes.
duty. That is 2nd May 2024,
Yes.
you said.
But,
Where is that order?
earlier occasions, my lord, before the coordinate bench, I have submitted that order.
আমরা কি করবো তাহলে?
Very well. It is on record, I think so, my lord.
Record.
Let me check whether I have any spare copy.
No, it has not been annexed.
No, subsequently, but
It has not been annexed.
not me.
File supplementary.
Yes, my lord, I got it. Yes, yes.
All right.
2 copies are here.
Bring it on record, na?
And on the last occasions also, I submitted before this honorable court. This is, my lord, official order dated 6th May 2024, whereby the second paragraph, in compliance with the Honorable Central Administrative Tribunal Kolkata bench, Kolkata order dated 7th March 2022, passed and so, Sri Pritam Majumdar, the respondent hearing, have been taken in the strength of DOCS Kolkata with effect from 2nd May 2024, subject to outcome of courts in the matter. So therefore, the period of
But subject to outcome, how?
that is an usual language, what I think so, but it appears to
In
me.
compliance of the Central Tribunal order of 7th March, in AO and CP such and such has taken in Pritam Majumdar is taken in the strength of Eto with effect from 2nd May. Acha.
The department will, yes, in compliance of the tribunal's order, did not rather force him to join in the transfer place of posting, rather in his original place of posting, he was.
Then he joined on.
He rejoined in his previous place of posting, not in the transfer place of posting.
Now, where are you denying him the benefits? Where is that order? That will be treated as spent on.
No, right now, before in this writ petition, we didn't say so, but it is the fact.
Did you pass any order?
No, subsequently, no order has been passed.
That period will be. That period will be treated as spent on duty if it is treated.
To that extent, no official order has been issued.
But the tribunal says
Tribunal says, my
The
lord,
date of disposal of the representation having spent on duty. Oh, that was his representation.
representation.
Did you consider that?
Yes, after considering this order has
But
been,
where is that rider as to how the leave will be given? This matter says only 6th May you will join. 2nd May.
So
then what happens to the period from 11th April to 2nd May?
prior to that, we have come before your lordship by filing the writ petition challenging
No,
this-
no, writ petition.
challenging the order of the tribunal, whereby the tribunal said partly allowed the way application.
Achha, let us understand. 6th May was the
2nd May was date of joining.
2nd May. And you filed the application when? 10th February 2026. This was filed much earlier, February 26. Your writ petition.
My writ petition prior to that, another writ petition was filed, subject to after obtaining the leave, we not refresh this writ petition. We have filed the fresh writ petitions. There are certain errors inadvertently, my lord. We didn't disclose certain facts and documents. We took leave from the court to withdraw.
When was that writ petition dismissed? Earlier writ petition?
Page 246. Page 240 order to date.
2nd July 2020.
2nd July 2025.
Second, page 246.
247. 248 is the order annexed. 248. Has been taken back.
He was kept out of the state.
During that
on
period,
that period.
because there was no stay order during that period.
Which stay order?
Which stay order?
Stay on that order of transfer. There was no order of stay.
Right.
What is release order, Mr. Nandi?
Release order.
Nothing but a consequential order of a transfer order.
Yes, on the same day it has been issued.
If the main order is stayed,
Main
but
order
the
state, my
consequential
humble,
orders-
that is why.
consequential order may be kept operative.
Well, I
or
tell you,
effective.
Lordship, why it is operative. My humble submission, Your Lordship. But kindly denote the dates of transfer.
What is it?
11th April 2022 is the date of transfer as well as release order. Since 11th April 2022 till 9th September 2024, there was no order of stay. Who prompted him not to join in his transfer place of posting at New Delhi? Rather, other two employees in a common transfer order was issued where they had joined, excepting this petitioner. One after another litigation cropped up. This respondent at first filed OA applications before the tribunal. Tribunal directed us.
Tribunal passed an order on stay on 11th of April.
11th
April
no,
2020.
for a limited period, my lord.
Then it was returnable when?
It was returnable on 5th. I tell you, Lordship.
It was continuing till the decision is made. It was continuing
No,
in the final.
no, my lord, there is no.
Interim
The
order was,
final order was passed in 7th March 2026.
yes, the interim order was existing in force.
Interim order was continuing. Then why didn't you go and join the post?
They did not allow me, my lord. Kindly see, my learned pen did not place the earlier order passed by this honorable bench. Kindly come to page 174. My lord has recorded everything in this order.
174.
174 of the volume 2.
That is the respondent moved
Yes.
writ petition.
I filed this case because my content was reserved for judgment for not allowing me duty. Page 74. This is the WPC filed by me, Peter Mojumdar.
Against what?
Against, my lord, the tribunal, what the tribunal has done, tribunal has passed grant an interim order. They did not implement the interim order. Despite my notice and despite the application filed by the petition, I may be allowed to resume duty. I filed a content. Tribunal was heard the content matter and reserved for judgment. But tribunal was sleeping tight over this matter. I approached before the Honorable High Court that Lordship, can you see the position? I am not getting the salary. I have not been allowed to resume duty.
So what did we say?
Now, Lordship, can you come to my lord findings? Come to paragraph.
Kindly see only directions.
Please, kindly come to page 180, my lord. It is specific, my lord. Page 180. A clear finding has been made by the Honorable.
Please come to 174.
180.
What order, please?
174 order has started. And my lord finding is 180. I am reading from top.
No, Mr. Das, kindly come to page 174.
174, yes.
The writ petitioner filed an original application before the tribunal challenging the order of transfer and the release order. In the first way, why? There are two ways.
Yes, yes.
So there is
Two
a
ways.
direction to consider my representation.
Initially, an interim order was passed on 18th April, observing and let the be not released, if not already released till the next day. If released, no coercive action should be taken. Finally disposed of on 5th May with the date. June 2020. Challenge. Where is internal page 2 of the judge order? Oh,
But kindly come to page 23 of my writ petition, earlier order.
in the same order was passed on 9th.
Oh, applicant transfer shall remain state.
Yes. But clear
It is not
point
specified that the transfer order will remain state. Transfer will,
Yes.
transfer includes release.
Yes.
Which includes release.
Constitute in this way.
Release to আমরা consider করেছি। Again challenge tribunal number 9 September file their affidavit by 4 weeks if any till such time petitioner remains state. আচ্ছা।
Till the exchange of affidavits.
That it has been extended.
No.
Why you are saying no?
Because I do not even I do not find any other orders.
180, the clear finding, they did not challenge this order before any other forum.
Yes, till the next date of hearing.
Page 180. My landed pen has appeared on that date.
Yes. That is 18th April order.
My landed pen appeared and argued this matter. You did not disclose my contempt petition in your writ petition. All the documents.
Yes, wanted to help.
করে এই অর্ডারটা পাস করে observations. Here review was transferred to their existing number 2009. When did you join? 2nd May.
After the order passed by this tribunal in a final order, they have passed an order that I was allowed to resume duty on.
Now what has happened to the contempt?
Contempt way has been disposed of analogously. If you
Contempt also disposed of?
Yes.
Contempt also disposed.
By our order? No.
After order passed by your lordship, my lord, they
Then
have disposed of.
contempt was disposed of, saying what?
But they have, tribunal has clapped OA and CPC together and passed this order. Contempt they did not pass. in separate. Because the clear violation, my lord. Now, my lord, entire 2 years salary they did not.
No, but
And now at what rate they are releasing salary? Pardon, my lord? At what rate? Old scale or they have given new
They
scale?
did not pay any month's salary last 2
Now
years.
presently they are paying.
Presently, after 2nd May 2024, I am getting. Regarding 22 to 24, tribunal has directed to release because there is a stay order.
Now
And they did not
whether they are treating this period as a backup service, baking service.
No order has been passed.
no order was.
It is a clear violation of the judicial procedure. Now the against by violation of that order, I file a contempt is pending.
Mr. Nondi, what is going on? Harassment. They're playing with the court also. They're playing with the judicial institution also. Since I have some power, a court tribunal by passing a specific interim order has stayed the transfer or transfer has stayed. As you are trying to divide, transfer order is separate thing, release order is separate thing. So the release order has a independent status. The release order has no independent status. Unless there is transfer order, release order shall have no value. The release order is nothing but a consequential order of a transfer order.
Lordship, I appreciate Lordship. That is the law.
That is.
That is the.
That should be.
Yes. Absolutely correct.
The general analogy. So if transfer order is stayed, it automatically it will lost its power to be operative.
Very good. Kindly come to minute, then first order of stay. 18th April, may I draw your lordship kind attentions on this order. Page, Lord, 18th April. Page 23 of my writ petition. No, 23. Arambho karto. 23. And this order dated?
One moment. Just one question. Pursuant to the first order of in the original application.
This one.
Order was directed to be passed.
Order was?
First way
order. I am pressing it for your lordship.
On the basis of first way, you were asked to dispose of their representation.
Second way.
Yes.
Disposal. That order.
5th May.
Huh?
5th May 2022.
Where is that order?
Page 25.
Page 25.
25 of my writ petition.
That is tribunal's order.
Tribunal's order. And direction of relevant portions of the order, the operating period is 27. At 27. Accordingly,
27.
27.
20, what did they say? Consider.
Decide the claim of the applicant.
This representation was against the order of transfer, no?
Yes. Yes.
So that was directed to be considered. Now this order was passed on 13th of June 22.
Lordship, the reason order.
Reason order rejecting his claim. You rejected?
Yes.
So that was challenged in the second.
That was in second way. And first interim order, as my lord just now pointed out to me, kindly come to page 24. What was the interim order passed at the threshold in first with regard to first way? Page 24 is relevant.
Yes.
Lardent Council so and so, Lardent Council for applicant, second paragraph. Lardent Council for applicant submits that the applicant has not been released, which is contradicted by Lardent Council for the respondents who submits that the applicant has already been released. Therefore, let the applicant be not released, if not already released, till the next date of listing, and if released, no coercive actions be taken against him. Yes, next date of listing. I'm pressing on this. Respondents to show that the applicant has been served release order prior 12:30 p.m. by this day. So this order was passed on 18th April and release order was passed on 11th April. So we brought it to the notice of the tribunal. The release order has already been issued.
Then after this, what happened?
After this 5th, Matter has been listed on 5th May, the order which I placed before your lordship right now, whereby the
consider
London
the
Tribunal was to
representative.
dispose of the way applications without confirming the interim order as passed on 18th. That was ifs and buts. If no release order has been passed, not to take any coercive steps. That was the order passed by the London Tribunal on 18th April. But we brought it to the notice of the London
You
Tribunal.
have
The order.
not yet passed an order that how you are treating that period. Till date, you have not passed an order.
Since we have joined him now, we are in administrative capacity. We are taking the decisions that
That is, you
we
are
have
trying
come
to
before
say
your
that
lordship challenging that order. If it goes,
Mr. Nandi,
Lordship.
your argument is there was a temporary interim order
Lordship.
till the next date of hearing. Till the next date of hearing,
Subject to other conditions. If
very
release order
good,
was not
it
issued,
was disposed of.
Disposed
Next, considered.
consider and dispose of. Pass a speaking order.
So that itself shows that you are not allowing him to join.
Because of the legal complications.
No, your argument is that order was limited up to the next date of hearing. Next date of hearing, application disposed of.
Lordship.
There is no direction how you have to treat that period of absence. He has challenged. Now these are inextricably bound. It is
That
not
is the interpretation is which requires interpretation. If subsequently, if I may take this point before your lordship, but as on date, transfer order has not been set aside by the tribunal.
Which one? Which one?
Transfer order has not been set aside. If your lordship kindly see the last paragraph of the order which is under challenge today before your lordship.
So you admit that yes, that is why I did not allow you to join. You admit that.
That's why I took out a review application.
Your argument is transfer order was not stayed. So you ought to have, you could not have joined the post from you have transferred. That itself shows that you are not willing to allow him to work.
Well, in my understanding, and also
show us that letter that how you have treated this period. You show what is your departmental instruction. You have not yet taken a decision. You have simply withheld the money because you are the employer.
Well, for a moment. But kindly give us 1 or 2 days time. We will take further instructions. Monday, keep it on Monday. But whether in the meantime any decisions has been taken, we are not been updated right now.
You are playing with the court, sir.
My humble submission is not at all. My humble submissions, it is our interpretations, but our understanding rather.
That is why we are asking, Mr. You were under the, you knew that the transfer order has not been stayed. That is your contention.
That is my contention.
So when the transfer order is not stayed, I will not allow you to join. This is the
Lordship, absolutely.
Corollary.
Yes.
So if the your decision is that I will not allow you to join. Now today you are taking the plea. Why didn't you go and join? Transfer order was stayed. This is self-contradictory. You are arguing.
Transfer order was stayed. When transfer order was stayed, when release order was, it has already been issued.
Very good. So you have proceeded on the basis. You are saying today that why will I pay him that amount? Why? You are right that he has not worked. So the issue which arises for consideration is whether it is a fact that he was not allowed to join, or he simply sat at home thinking High Court will ultimately hold in my favor.
But
this is not expected, na? So your authorities were predetermined. Your authorities were predetermined that I will not allow you to enter. Let us see what the High Court will do.
Ultimately, authority allowed him.
That is only when we pass this order that authority should not act in such a manner.
No coercive.
Justice demands fair play.
So
just because you are the railway and you are the lion, I will not allow you to join. Let the High Court decide.
No,
you are wasting state exchequer.
So when you have joined, allowed to join to his parent posting, now what is the fate of your release order and transfer order?
It goes.
Huh?
It goes because
impliedly it goes.
It goes automatically. It goes because we allowed him to join in your original place of posting, not to the transfer place of posting in Kolkata.
No, that you did not. That ultimately after.
So we have shown our fairness. No. We have shown a highest regard with this. We have highest regard with this.
Fairness, whether if you think
we never said so that liberty was given to us by the London Tribunal to reconsider and rethink on the issue of transfer. Then we allowed him to rejoin in his original place of posting. Not we never asked to join in Delhi. like other employees. In a common transfer order, repeatedly, my lord, I once again I submit.
Sir Nandi, your primary argument is why should I pay him when he has not worked?
Not.
This is your argument.
This is very simple. We are agreed only
So
this part.
how will he work if you don't allow him?
It is not a case we did not allow. It is a case, my lord, if your lordship kindly make a
Alright.
scrutiny on it,
Sir,
that due
release
to
order was
various
served upon
proceedings.
you. Release order was served upon you.
No.
It is a disputed question.
Disputed. That is why tribunal has passed.
Never, he never denied in his rejoinder. The release order was not served upon
Tribunal
him.
has been passed.
I invite this, the challenge from my learned friend. So show before this honorable court that release order was not issued, not served upon him.
As far as it is.
ওটার সঙ্গে কোনো সম্পর্ক নেই।
Interim order. And tribunal inherently pass the interim order applicants. Kindly see their documents, page 21. This is the second way tribunal when the interim order has been passed.
It will transfer the state data.
Page 21.
21?
It is your document. Page 21. আপনার interim order copy তো দেননি আপনি। কপিটাই দেয়নি।
Yes, anything else, Mr. Nandi?
Lordship, this is only one point. Kindly consider these things the public exchequers. So a person did not serve for the nations. So whether he is entitled to get any the salary or any perquisites or service benefits during that period. So kindly consider this part we are agreed with only that portions of the order. So the person did not work, did not render his service. for the country. And he's claiming, suppose
Mr. Nondi, you are not answering our query. We are willing to help you. You show us. You admittedly till date, that is in 2026, we are in July.
Lordship.
You have not passed any order as to how, or you did not express your opinion, how you wish to decide that period to be. You have not said that you have not yet passed an order that that will continue, that will be your regular service with no salary.
Kindly give us 1 or 2 days time, because in the meantime, this matter has been appearing since long. There is a communication gap between the client and the
That you should
council.
have told us first.
Yes,
Now we have gone
only
into
1 or
the
2 days we'll come with these documents, whether it has been issued or not. Any decisions has been taken or not, we'll bring it to the notice of this honorable court on Monday. Kindly give us 1 or 2 days time. Just give us 2 days time.
No, Mr. Nondi.
If it is already there on the record, so and today if your lordship passes any order, that will contradict. Whether my client has taken, whether my client has taken already taken any decision or not, give us an opportunity, but only 2 days. Monday or Tuesday, keeping this matter.
Contempt proceedings, it was pending. Tribunal repeatedly directed whether any order has been passed. They did not produce any order in a contempt proceeding, which is also pending before this court.
Pending, it has been disposed of.
Disposed after the final order has been passed. When they did not comply with this order, I find another contempt for non-compliance of the order. Matter was appeared day before yesterday.
But what is fallen from
And
your
they
lordship's
did not-
mind?
they
Kindly
did not
pass an
produce any
order
piece of paper.
on directors to
No,
produce
no,
the.
that will be a fresh cause of action. You will come and argue now we have passed a fresh order, let you go to the tribunal.
Yes,
That-
Mr. Nondi.
No, we will not.
You
We
will pass
will
a
not.
fresh
We will
order?
not pass any fresh order.
Ah.
I undertake your lordship.
This thinking is.
Today's date, 15. We are on 15 July. 15 July is order. If it has already been taken place, if it is on the record of the department, will come with that
We
order.
have communicated that. If there was any order,
I want to ascertain this part. Not on 15th onwards. Not on 15th onwards.
Sorry, Mr. No. The present writ petition has been preferred.
beg to appear on behalf of my lord petitioner, my lord. This public interest litigation, my lord, has been filed against my lord a seditious speech, my lord, delivered by the my lord private respondent in a political gathering on 2nd June 2010.
Item? Yes.
A seditious speech delivered by my lord private respondent in a my lord political gathering on 2nd June to my lord 2026. The sum and substance of that my lord statement is that my lord that one murderer, who killed a renowned politician in Bangladesh, my lord, came to my lord West Bengal, and my lord West Bengal STF arrested him, but due to intervention of the my lord central government, he was my lord released. That is the sum and substance. It creates a my lord uproar in the my lord neighboring country also, my lord. So my lord, I have lodged a complaint before the my lord police authority. My lord, they have not till date, my lord.
Yes. A statement that the
Four. Sorry, eight. Oh, Amit. Energy.
Yes.
Yes, my lord. That, my lord, whether that statement, my lord, discloses a cognizable offense or not, my lord. So my humble submission is, my lord, answer is, my lord, positive because
Any proceeding
153.
initiated?
I don't know, my lord.
Initiated
State will,
any-
my lord, respond to this, my lord. Because it also, my lord, offense
No,
under
your
the
representation is 5th June.
5th June. Very soon, my lord, it is lodged before the my lord, here State Police Station.
So this has not been treated as FIR.
Yes. And second, my lord, another my lord, limb
Then
of
why you are
argument.
coming before us?
Another limb of argument, my lord, because, my lord, whether, my lord, that statement, my lord, comes within the purview of, my lord, NIA, my lord.
No, that
National,
will be, that is a question, that is an issue to be decided in course of
involves,
investigation.
yes, it involves, my lord, national security
complaint
also.
has not been treated as, your complaint has not been treated as a FIR.
Then my lord, state shall respond to this, my lord, whether that complaint has been treated or not, my lord. Till I do not know, my lord, whether.
So it doesn't appear that the complaint has been accepted. So your remedy is before the magistrate. Go and file an application 154.3. Treat my
Whether, my lord, it
complaint as
involves the public interest or not, my lord. Kindly look into this, my lord. A speech is made, my lord, which, my lord, affects the, my lord.
Let us understand. Suppose a person has
It's not the
made a
personal action, my lord. It's not the personal action.
public interest litigation, you are coming.
Yes.
Without exhausting the remedies which are given to you under the Act. Please consider, please consider. This is a very, this allegation which has been made, this is the subject matter of your complaint. And you are arguing that it is a hate speech. The
Not hate speech, seditious speech, my lord. Not, it is, my
You
lord.
stated hate anyway, that was your averment.
If your complaint is accepted and registered a case on the basis of the case is registered, then your status will be de facto complainant. De facto complainant. So you will be party to the proceedings.
Yes.
You are not mere public spirited person. Your specific grievance is that I lodge a complaint before the concerned officer in charge.
No, here the
The
complaint.
concerned officer in charge should have accepted him, and on the basis of him, a case should have been initiated.
Here, my lord,
It
complainant,
is your specific conception. In that circumstances, you will be de facto complainant.
mother kindly consider whether it
It is
involves
not.
small involves my lady personal my lord against the this is for the
Then-
personal interest of the petitioner.
Then if any person's complaint is not accepted or any case is not registered,
Yes.
then his remedy would be to approach the SP first. Order 156, clause 3, then you have to file an application under old CRPC. You have to file an application before the magistrate, complaint before the magistrate.
But that is what my lord, I bow down you to your lordship
Fine.
observation.
It is
But
remedy.
one thing is that my lord, it is not involves my lord any personal my lord
It is-
grievances.
It is because complaint was lodged by you. You are the petitioner.
But for sum and substance, my lord, it
Please,
my lord.
please consider the acceptance. If you withdraw and file with appropriate material, that is an issue. But suppose it will be your contention is a hate speech has been delivered. You are coming with a public interest litigation. What is your prayer? That you issue necessary direction
To the NIA also, my lord. It's another.
to initiate proceeding under NIA.
Yes.
Who is making this prayer? You. But you had been a de facto complainant once it is received. How can you come and file a public interest litigation? It is between the complainant and the person accused. And you put yourself in that post because you have made the complaint to the police. This is not.
But
maintainable.
here, my lord, what has fallen from your lordship, my lord, that my lord,
Come in a proper manner or you withdraw the petition.
Publicity interest litigation or private interest.
Either you avail necessary remedies before the provisions which are provided, and you withdraw the petition. Go and
if this type of statement is made, my lord, what is it, my lord?
We are not on that, sir. We are on the issue as regards your locus. It is clearly, if you argue on that point, you may argue, but prima facie it appears that it will be difficult for you to overcome this issue. We could have understood that X, Y, Z along with you came. X has lodged a complaint, but Y and Z and myself is filing the public interest litigation. Then also we can understand. But you are the de facto complainant, sir. Your allegation is police is not taking cognizance of this. Withdraw.
My lord, kindly, my lord, then my lord, I shall my lord address on this issue, my lord, what has fallen from recent judgment.
Pass our order.
My lord, recent judgment passed by the Honorable Supreme Court, my lord, regarding my lord, hate speech, my lord. I think my lord, it covers my.
You should have any.
Hate speech is a subject matter.
No,
You
it
forget
covers my
about
lord. The conclusion
you
is
address the issue raised by us. First, your locus. It is your personal matter, not public interest. We do not find any personality. You, as a person, you lodge a FIR before an officer in charge. Now your grievances is there.
Particulars, then you try your luck.
What better because that speech is there, everything as well given to the my lord police.
So then you argue, sir. We have expressed our concern to
So
you.
far, your lordship has not asked for the locus stand. Kindly fix a date. I shall not address on
Why
this
should
one.
we fix a date? It cannot be just a. Why, sir? You made the argument. You are not prepared.
I have not. Because my lord, we
You
are.
the state. No.
I am not. I'm union.
Sorry.
Union.
You are the. Mr. Banerjee, you are for?
Well, I am for the response number 8. I have nothing to do with this. It's only the newspaper which had the online
I am
article which is
appearing for
I have
1,
nothing
3.
actually not involved in this.
Editor.
I am representing 1, 3 and 5.
Then also I find the editor has been made a party. It should really be the company. If at all I only carried whatever. Several other newspapers also carried.
No.
Locus, my lord, then my lord, to kindly fix the date, my lord, next week, my lord.
You should have.
Yes, my lord.
Yes.
Yes. Next, my lord, week, my lord, can you fix, my lord, next week, I shall have.
In course of hearing, the learned ওনাদের অ্যাপিয়ারেন্স দিয়ে দিও সব।
My lord, I am the petitioner. I am doing the in person, my lord. The matter is.
You are an advocate, na?
Yes, my lord, in this court.
It is your problem. Your problem.
No. Common problem is the district court and subdivisional court. There is no government panel, and the litigation against the government is not doing anything. I know that in Alipur court, Barasat court, and Boshirat court, no GP is functioning, and it is for the smooth functioning of the justice delivery system.
Party. You have not made DM as party.
My lord, DM is not mainly. I have prayed for the recommendation from the government, and this is the I have stated in the paragraph number 8. Yes. Yes, in the last occasion appeared, my lord. On the paragraph number 8, I have stated the procedure.
On behalf of the legal remembrance, and your lordship, report has already been submitted to us, and kindly my lord, report by the LR is already with us, my lord.
What does it say?
My lord, 17 district magistrates have already forwarded their list of names of the lawyers, and others are under process. We will be complying with it very soon, my lord, and I will be submitting this report on the next date, on Monday, my lord.
You are for the legal remembrance?
Respondent number 4, your lordship.
Legal remembrance is the.
You want your problem to be solved. We are trying for solution of the problem.
I'm being led by Mr. Bhattacharya, learned additional advocate general.
Hard learned advocate appearing for the
the issuance of the notification by the LR.
We understand.
The
we
list,
understand.
list, nothing but.
Understand.
Yes, my lord, if date is earlier, better the all courts are is not running against the government litigation all over West Bengal, my lord.
We have kept it on 4th. We are giving them 2 weeks time. If by this time
No,
everything is fine,
he prayed for Monday. That list is
you can
prepared.
do it by Monday.
Monday.
Why not only one day accommodation as Mr.
Yes, my lord.
আচ্ছা, তাহলে
Notice
We
having
want
job.
report regarding the entire state of West
Yes,
Bengal.
it's already with us, my lord. I will file.
try
for-
to understand what we have recorded. We have said that you are seeking time to come up with a report addressing the grievance of the petitioner. Understood?
Gotcha.
So ask your LR or whoever is the competent person to prepare a report and then you place it before us. So when you can place it on, you're saying then we are keeping it on 20. Today we are on 16th.
Monday. She
Come on
prayed for Monday.
23rd. Come on 23rd. We give you 1 week.
Fine.
Consult.
Grateful.
My lord.
Yes.
Oblige, oblige.
Taku.
My lord, item 12, your lordship, I appear for the, my lord, petitioner.
You are for?
Petitioner.
My lord, he is assisting me. He is assisting me, your lordship.
Where is your other side?
A copy has.
My lord, it has been duly served.
Affidavit of service is there.
My lord, the subject matter pertains, my lord, to
Your
the...
other side is not here. Let us see if anybody appears.
Very well, my lord.
You are there.
Yes, my lord. Not.
He has already served.
Very well, my lord. Let him argue.
What is the matter about?
My lord, the matter is about, my lord, the special attendants who, my lord, serves or give, my lord, service in all the government hospitals, my lord, in the state of West Bengal. My lord, if your lordship kindly sees, my lord, page 43, that there was a memorandum, my lord, dated 10th of August 1981, wherein, my lord, it has been stated that, my lord, a person who has served as a special attendant, my lord, in the government hospital, my lord, for more than 5 years, consecutive years, and my lord, at least 240 days of service in each of 3 years, my lord, will be, my lord, nominated or will be given appointment in the vacant posts of Group D.
How
So,
it is a public interest litigation?
my lord, my lord. So, my lord, there was a regulation of 1981, my lord, that in course of that regulation, my lord, lists were being prepared. That who are the special attendants, my lord, who are giving services in government hospitals throughout the state of West Bengal. Here, my lord, I am concerned regarding the special attendants, my lord, who were giving service throughout, my lord, till 2026 in the NRS Medical College and Hospital. My lord, by a notification latest, my lord, that is dated, your lordship, yes, my lord, page 224, P24, page 257, my lord, this notification was published dated 20th of May 2026, wherein, my lord, the old I-cards were all being asked to be newly renewed by the government. And my lord, in the course of this renewal, my lord, the ID cards which were issued to the special attendants post the independence, my lord, throughout, my lord, and the special attendants after in generation wise have been working in government hospitals, this, my lord, renewal of the
How
ID
is
cards
it a
were
public
stopped.
interest litigation?
No.
How is it a public interest litigation?
Yes, my lord.
You were being given, you were initially given a card. Now, after so many years, they are trying to say
No, my lord,
that
the petitioner is not the special attendant over here, my lord.
Pardon?
The petitioner is not the special attendant himself. Petitioner,
so
my lord.
Who is the person aggrieved then?
My lord, the entire, my lord, the community at large, my lord.
So
Kindly
that is
sees,
for
my
them
lord, there
to
are more
decide.
than 10,000 special attendants working in the state of West Bengal. My lord, today, by the course of this order, who were all working from the date of independence till date, by virtue of their ID cards being issued by the government authorities, now...
Who are you? Who are you?
My lord, I am a citizen of India, my lord, who serves socially, your lordship. I am no way connected, my lord,
You
personally.
answer one question.
Yes,
You
my lord.
answer one
Yes,
question.
yes, yes.
Did anybody, any special attendant who were allegedly working, have they challenged this notification in any
Yes, yes,
meeting?
yes, my lord. They have all made representations before the authorities.
So then it is for them to carry on the cause. Who are you? They
My lord,
have lodged protest against the government notification. It
absolutely.
intersect the government and those persons who are special attendants.
Throughout
Those matters
the
are
state of West Bengal.
appropriate forum. Though they have challenged that matter, what is the result? What had been the outcome of that?
No, nobody had challenged it, my lord. Only representations are being made.
So they should take necessary steps.
Only
They
that
should
is why,
file
my
an
lord. That is why, my lord, the petitioner before your lordship had caused the, my lord, public interest litigation, my lord, for the cause of the society at large, because the service to be provided in the government hospitals are all being affected. My lord, kindly cease.
You give a copy.
My lord, I am not today asking for any service. My lord, today, my lord, I am not before your court, my
All
lord,
right,
asking.
let us ascertain. Let us ascertain you. We are engaging Mr. Mishro.
Very well.
Ask your junior to give a copy to Mr. Mishro. You
My lord, we have downloaded it, my lord.
Today only
We
I
have
will give,
downloaded
my
it.
lord. Today only I will give, my lord. Let Mr. Mishro, my lord, file a report before your lordship to this effect.
Learned advocate appearing for the petitioner as no one affidavit of service, comma, as filed, comma, be kept on record. In spite of service, no one appears on behalf of the state respondents. For hard Mr. Mondor learned advocate appearing for the petitioner as no one appears on behalf of the state, comma, we request Mr. Mishra, learned advocate, AGP, appear on behalf of to appear for the state respondents along with a junior of his choice. Let such engagement be regularized. Can you do you have a copy?
Yes, my lord, we have downloaded it.
My lord, yes, my junior will, my lord, serve a copy today
Yes,
itself. Today
Yes,
itself.
we have got the copy.
My lord, what I am seeking today, my lord, is to call for a report, my lord, from the learned AGP, so that, my lord, the status may be placed before your lordships.
Come with the instruction. This
Very
is
well.
matter for
Very
further
well.
consideration in the daily supplementary list of this court on 7th August. Mr. Mishro is
My lord,
directed to
my
avail
lord,
all
instead of, my lord, 7th August, could it be any date prior or after 7th August? I am in some personal difficulty, my lord.
11th
11th August. Very well. 11th.
August.
Very well, my lord.
My lord is keeping it on 11th.
11th.
Grateful, my lord.
You avail, Mr. Mishro.
Yes, yes.
To avail all necessary instruction.
My lord. Deeply obliged, your lordship. Deeply obliged.
Deeply obliged.
Matlab 13, Matlab, I'm appealing for the state. I'm led by Mr. Bilodal Bhattacharya. There's only one thing: the matter could be taken up on Monday, my lord.
Why? Why? Matter, my lord, I am for the petitioner.
Matlab, I'm representing the state. Matlab, I'm led by Mr. Bhattacharya. Bilodal Bhattacharya. It could only
In that
taken up on
case, my lord,
Monday, my lord.
kindly direct him to bring the report, my lord, on the. May I only submit that? So this is
Come on Monday. Yes. Next.
Grateful, my lord.
What I be flipping. Lord, by an order dated 19th January 2026.
You, sir.
Yes, Mr. Mishra was appointed.
Yes, yes, yes. My lord. I'm getting in this.
Was supposed to file a report, my lord, because by an order dated 19 January 2026. There was a direction to file a report.
19 January.
19 January. Continue.
My lord, we have sought instruction, my lord. It will take another 2 weeks, my lord, in this matter, my lord. Subsequently, we have been appointed by the court, my lord. This prior order was in January, my lord.
There was no direction for
Yes, ma'am. 19 January 2026.
19
January 2026. The erstwhile bench on
January 26.
26, my lord.
Yes, file it.
My lord, we have sought
subsequently.
instructions on this matter, my lord. Subsequently, we have been engaged, my lord. We have sought instruction. Last order does not say so, but in spite of that, my lord, we have sought instruction, my lord.
5th August.
5th of August, my lord. Grateful. Much obliged. Union of India, sir.
My lord, I appear on behalf of the petitioner, my lord.
You're there.
My lord, on the last occasion, lordship directed. On the last occasion, lordship directed to take instruction from the others.
Come on Monday. Where is your other side? Who appeared?
Yes, my lord, someone was appearing on the last occasion.
Appeared?
Yes, my lord. A lady advocate of the
Rishmi Botra. Please. Come on Monday. Come on Monday, let us.
Lordship.
Yes.
In my lord, I am appearing for the petitioner.
My lord, I am appearing on behalf of the state, my lord. The survey has been concluded, my lord. This is respect to a pond, my lord. Survey has been completed. Within a day or two, my lord, we will file the report.
But we are for the private respondent. It is not pond. It is a khal. Canal. Canal. It has been recorded as khal. It is our land. We are riots. Only, my lord, the meant for irrigation. Irrigation department has not been made party. And my lord, this is not a public interest litigation, but they are, my lord, encroaching the khal. That's why, my lord, we filed a writ petition before the Panchayat authority.
It's number 24335.
Yes. That's why, my lord, it is a counter blast. Public interest litigation by brother.
Lord, I am not a party over the
No,
matter.
I know, I know. Both of sons of Bholanath.
Who will be filing the report, Mr. Mishra?
My lord, I have asked the BDO, my lord. They have concluded the survey, my lord. As being told, my lord, they have concluded the survey of the area within a day or two, my lord. If
Can we record that?
yes, yes, my lord. Day or Friday or Monday, keep it on Monday. By that time, we will put that, my lord. Survey has been done, my lord. On instruction, I am.
It is not maintainable. Whatever.
আমরা instruction দিয়ে দিচ্ছি না।
My lord, my lord.
In course of hearing, Mr. Lanet,
by Mr. Vikas Bhattacharya in this matter, my lord. My lord, this is the matter.
OBC.
No. Well, this is the matter, my lord, where on the last occasion, learned Additional Solicitor General had submitted, and
seriously.
this is. Are you going to do the matter? No, I'm just going to. You have made your submission
What
on the last.
you are wanting, Mr. Chatterjee?
My lord,
You are wanting time or you want to
no,
do?
I want only. I have only one
If
prayer.
you want time, then tell us.
I have only one prayer, my lord. On the last occasion, Mr. Trivedi said that this land has been allotted in the name of one or two persons. They are given. They are the tenderee who has got the tender. to construct something on the land which is vacant and used as a playground. But if they give the name of those persons, we can make them the party. That is one aspect to this.
File an application, take the names from Mr. Trivedi.
That is one aspect to this. Second aspect, my lord, this land was used as a playground. It's a land situated in the bank of river Ganges.
You come with
But
those.
they have closed. I have given it. My lord,
Come with an application if you want to file. Or you argue the matter. You want to impeach somebody.
we have to implement. So
Come
let
with
them.
an application.
আমাকে number
দিয়ে
বলো।
দেবো আমি স্যারকে বলে দিয়েছি আগেই
Let Mr. Trivedi.
Malad, I spoke
Bhattacharya
to
has
my learned
instructed me.
senior, Malad, and I
So that's
told
why
him,
he
and
made
I
this
put him
submission. my lord.
on notice that this is the technical issue.
Mr. Bhattacharya
I
had,
a word for that.
Mr. Bhattacharya said that.
I did not want to
so if-
waste my lord's judicial time, Malad.
So if it is given,
File
so I'll make them.
Then file within a week.
I'll
Application.
file within 2
It
days.
will not be because you have to complete service. We
Yes,
have to
my lord,
allow the
keep it on the
application.
Monday next, my lord.
No, Monday. File the application, serve copy, then we will come.
Malad, the next matter is all analogous. Two matters.
19 and
17 and 18.
17
17 and 18.
18.
so
Petitioners
you
are
are
different.
appearing, Mr. Chatterjee.
No, one matter. One is Mr.
Tariq Kashmir, Mr.
You also want to add
Tariq
them.
Kashmuddin.
Acha, Mr. Chatterjee, learned advocate appearing
That
for
is
the
the advice
petitioner,
from my lord senior. my lord.
praise for Fifth August. Then come on 10th August. 10th August. 10th August.
Grateful.
Yes, next.
এইখানেই তো।
Good, I appeal for the petitioner. But this is the continuation of, my lord, that OBC A and OBC B declaration. Now, my lord, after change of regime, my lord, the present state government has done away with everything what was done by the previous government. Now, my lord, the notifications which are under challenge, your lordships may kindly have a look, my lord, to page number
My lord,
88.
before my learned
No,
friend
I've checked up,
submit,
I've checked up. That is something different.
sir, all the matters are on.
No, 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 no.
On 27th August, my lord, this has been, learned AG is leading in the matter, my lord. 27th of August, my lord, similar matters have been placed before my lord. OBC matters, my lord. 3 or 4 other matters are also there. My lord has been pleased to fix all those matters on 27th, my lord.
Mr. Dotto, come on that date.
My lord, I am told, my lord, subject to correction by my learned friend, my lord, in those writ petitions, my lord, the re-verification notifications of 14th of May 2026 are under challenge. These are not under challenge in my writ petition. Kindly have a look to this notification.
it
Again,
is
subject to correction.
Pertaining to the same issue, na, Mr. Dotto.
No. This is, my lord, re-verification of the caste certificates which have already been issued pursuant to the previous notifications. And our writ petition, my writ petition, is doing away with the previous notifications. But if your lordships may kindly, just for recollection purpose, my lord, in 2010, my lord, certain, my lord, classes were notified as, my lord, OBC. And, my lord, there was a subclassification as OBC A and OBC B. My lord, the division bench of Justice Chakraborty and Justice Mantha, my lord, by an order of May 2024, was pleased to struck down those. There were various directions. Few of the provisions were struck of the act was struck down, and your lordships were pleased to lay down as to how again it can be done. Like your lordships were pleased to observe that the commission's recommendations are all binding, ordinarily binding. Then your lordships were pleased to lay down that after you do the exercise or the commission does the exercise, before declaration, it must be placed before the legislature. various directions were passed. Now, my lord, from that, my lord, appeal was preferred, I mean, SLP was taken to the Supreme Court. There was no stay. In the SLP, my lord, the then state government went and informed the Supreme Court that in terms of your lordship's direction of May 2024, a fresh exercise is being undertaken. The Supreme Court notes that and allows the fresh steps to be taken. In terms of your lordship's May 2024 order, my lord, fresh verification was done by the commission, fresh recommendations were made. Then, my lord, the report was placed before the legislature and fresh notifications were issued in 2025. The previous ones were of 2010, which your lordships were pleased to set aside. Now, the new notifications of 2025 again fell for challenge in a second round of litigation. The same division bench, my lord, in May 2026, my lord, was pleased to, my lord, stay all the notifications which were published, my lord, after, my lord, complying with the directions of May 2024 order. Against that, my lord, there was a challenge in the second round of litigation. It went before the Supreme Court, and my lord, the Supreme Court was pleased to pass an order of stay. Subsequently, there was a contempt application. Supreme Court stayed all the contempt proceedings. Now, this is, my lord, what had happened. Now, my lord, there is a change of regime. Now, after the change of regime, my lord, all the notifications which were the subject matter of the second round of litigation have been withdrawn now, which is under challenge in this writ petition. Possibly, my lord, on that, my lord, there is no writ petition pending. Only one writ petition was moved by Mr. Pradeep Kumar Tarvda, learned senior advocate. Your lordships were pleased not to entertain that. I have that order also. On the last occasion, your lordships were pleased to, my lord, refer to that order, saying that since your lordships had taken a view in one matter, the other, on the same issue, my lord, your lordship would not be inclined to take any other view. It's a copy. And my lord, subsequent to the dismissal of the previous PIL, where now, my lord, the present state government has, my lord, withdrawn all the SLPs.
Notifications challenged in the second writ petition, in respect of which Supreme Court passed an order of stay, new regime government has withdrawn those
notifications.
Then what is your grievance today?
My lord, only, my lord, one more fact I need to, my lord, tell your lordship. In between, my lord, today and last day's hearing, my lord, the state government has withdrawn all the SLPs from the Supreme Court. Therefore, today nothing is pending before the Supreme Court.
I see. So now you are challenging any further notification has been issued?
Yes, withdrawing the 2025 notifications, which were subject matter of the second round of litigation.
Do you think that it will be better if this is heard by myself and Justice Mantha?
But I have no choice. It's
No, not a
just feel proper, my lord. I
And Mr. Misro, if we keep
the learned advocate general is
this for Union of India.
But Union of India, in my submission.
Yes, then do you have any issue if we constitute a bench?
Let me
Myself,
take instructions from Advocate General, my lord, because since he's leading in all these matters relating to that OBC withdrawal and notifications, my lord.
Then come and what?
My lord, kindly take up that to
No,
my lord.
we do not want to see, there has to be a uniformity in what we do.
My lord.
A special, that why it has struck me, because that specially that bench was constituted for deciding the matter.
My lord, in that event, this is an administrative decision of my lord, my lord.
Exactly, exactly, that is. Mr. Dotto, can your advocate on record just give a formal notice to us in the secretariat so that we can constitute the bench? এই সম্রাট কোথায় গো? সম্রাট to his lordship's what we said. Then ask your advocate general to appear before us.
My lord.
And any instruction you have to seek, you do it.
My lord.
Just put in a letter.
Very
ধরুন ৭ থেকে ডাউনলোড করে এই যে সার্কিটের একটা
For the applicant, my lord. Pursuant to my lord direction, my lord. Pursuant to my lord direction, I am filing the residential certificate by an affidavit, my lord.
আমি প্রধান সব একসাথে হ্যাঁ একসাথে প্রধান 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 প্রাইভেট
এটাই affidavit.
কি দিচ্ছে নিরঞ্জন সেটাই করতে বল ওখান থেকে জেম
You have served everybody? Private respondent?
My lord, I am appearing for private respondent.
Yes, tell us what is.
Pursuant to my last occasion, your lordship directed to the state government to take necessary instruction in the meantime. Can you come last order?
Yes, who is what is.
My lord, we've, my lord, obtained instructions. My lord, I'm sorry, my lord, this is not sewn, my lord, this is stapled. I'm sorry, my lord. My lord, there it was, my lord, inquiry has revealed, my lord, that the private respondent numbers 18, 19, and 20 are patta holders. My lord, then, my lord, 11 to 17 had allowed them to occupy certain portions for residential purpose, considering their poverty. My lord, now, ultimately, my lord, it has,
17 and 18.
my lord, 18, 19, and 20.
My lord, I am
patta
appearing.
holders.
I am appearing.
Patta holders, my lord.
And 11 to 17.
My lord, 11 to 17, my lord, if I may place, considering the extremely poor financial condition and landless status of respondent numbers 11 to 17, the patta holders had allowed them to occupy certain portions of the land for residential purposes on humanitarian grounds. My lord, this is Sali land. My lord, next page, if I may trouble my lords. My lord, third paragraph at the next second page, my lord. Upon verification of the facts, it appears that the dispute substantially, my lord, relates to the nature, classification, and use of the land, as well as the legality of constructions. My lord, this falls within, my lord, the revenue, my lord, and land reforms authorities, my lord. Lord, they filed a representation that can, my lord, be considered by the authorities.
What instruction from police?
My lord, yes, that's.
Huh?
Yes, my lord.
Police.
My lord, the STO, my lord, the subdivisional officer, my lord, whom they had, my lord, made the representations, my lord, they will, my lord, my lord, we will also place a supplementary affidavit and particulars before them, my lord, as to what is the status, my lord, of the constructions.
My lord, may I
My lord,
indicate
perhaps, my lord, they can consider the representation, my lord, that's their prayer, my lord.
My lord, may I indicate one thing? My lord, what is the contention of the petitioner before the street petition? My lord, 18 to 20, they are the patta holders, and my lord, they are using the Sali land without any conversion, and they are making a construction without any plan sanctioned by the competent authority. On the last occasion, your lordship directed me as well as the petitioner to show the document, as because, my lord, my contention on the earlier occasion, that it's not a public interest litigation, it's a purely private individual litigation, and we have, my lord, we have made an objection before the authority that his classification, he has not also had the conversion land and he constructed the building without any sanction plan. That's why your lordship on the earlier occasion directed both of us to produce the conversion as well as the sanction plan. My lord, I have come with that.
আচ্ছা এগুলো সব
প্রধানের কি খবর
My lord, I hope, my lord, my learned friend being an public interest litigation, he also have all the document. My lord, he is only annexed. What he annexed? He annexed. And my lord, second thing, my lord, the Pradhan,
Lord, may I submit if your lordship, with your lordship kindly, Lord, on the last occasion, I am appealing for the Pradhan, Lord. Appealing for the Pradhan, Lord. Lord, on the last occasion, yes.
And my lord, one thing, on the last occasion, on the earlier,
What you are showing us?
my lord,
What is this you are showing us?
my lord, I just indicate one thing, kindly come to my instruction, my lord, last page, first. My lord, got it? This is it. My lord, on the last occasion on 30/7/2026, my lord, the Pradhan has issued a hearing notice. Both the petitioner and the private respondent to show all the document and under section 23 subclause 5. My lord, we attended the hearing. My lord, but before that page, my lord, kindly see. Excuse me.
No, I can't, Mr. Chair.
Yes.
My lord, kindly see, my lord, before that page, my lord, on 14/5/2026, my lord, we are made a representation before the Pradhan that his and his family's construction is illegal.
What's the sanction plan?
My lord, we have filed it before the Pradhan. My lord, we have annexed it. That is sanctioned.
Which is your building?
Not yet sanctioned.
Not yet sanctioned.
Then how you are raising construction?
Well, I am not raising construction. The Pradhan has stopped me. We have not raising any construction.
The partly built structure?
My lord, that is we have already applied for. My lord, kindly see.
Applying for you will
My
start.
lord, knows that. My lord, what is the village situation?
No, what we have to know, Mr. Das, that by applying for sanction, one can raise the building.
No, we are stopping it. My lord, we have not raised further. Whenever the Pradhan and your lordship has directed us not to raise any further construction, any construction, we have stopped it.
Where is the Pradhan's order that don't raise further?
Lord,
My lord, last.
This is the notice we have issued, Lord, directing them to stop construction. In the meantime, we have asked them to, we have held the inspection in respect of that plot, Lord. And we have fixed the matter for further hearing consideration on 22nd. 22nd
of July.
Your lordship.
Pradhan, my lord,
We have already,
Final decision before us.
my Pradhan issued.
Lord, we will certainly take. Then inspection has been done yesterday, my lord. And thereafter we have fixed for 22nd for final.
They raised the construction when they were not having sanction plan.
Lord, that is why we have asked them to stop.
There is no problem, everything is okay.
And the petitioner is also raising a construction without any
Yes, your
sanction.
lordship.
Forget about that. We are asking about your construction.
My lord, we have
That
raised.
petitioner has done or not, that will come.
My lord, we complained first. My
That's what made you to raise the construction without the plan.
My lord, kindly see in
Then
20.
everything is forcibly going
No,
on.
my lord, 2024, my lord, we have already
But no,
applied for the conversion. My lord, that is also pending.
then how can you raise the construction,
My
sir?
lord, 2024.
Yes.
My lord, one storage, my lord.
What you are saying, Mr. Das? I will not get the classification changed. I will not get a sanction building plan and I will start my construction.
My lord, we have already stopped, my lord.
That is not an excuse. You sit with them and come before us.
Certainly, that is the notice we have issued. Your lordship kindly, that the notice dated 13. Your lordship kindly, the bottom portion, we have stated that, my lord.
On Pradhan issued notice on.
Your client is very adamant.
No. Whatever he has done, my lord, but.
Here, where are you staying?
On the Pradhan issued notice on 13 July.
In our Pradhan, where is your plot of land? Where is your plot of land?
Beside the land of this
So,
plot.
is that a vacant land?
Yes, madam.
Huh?
Vacant land. No, madam, not vacant land. Constant.
Produce your plan also. We will
No,
demolish.
that is separate matter, my lord. After proceeding, he may call for this report, my lord.
Court is asking you. That is separate matter maybe for you. You will also produce all your relevant documents. These are all private interests then.
Yes, my lord.
Yes, your lordship.
You have
Yes,
to
your lordship.
produce all your documents to show that the structure in which you are staying is also a sanctioned structure. You are the owner of the land.
Yes, my lord. My Patta
holder.
Pardon, father.
Another patta holder.
Patta holder without
patta.
conversion, he is
No
making
patta holder.
construction without any sanction.
Purchase land. My lord, purchase land.
We
Purchase
have
land.
You have purchased.
Yes, purchase land.
Purchased
Huh?
in which year?
Purchase land.
that
Petitioner.
is also
How we can purchase the patta land? How we can purchase the patta land?
I have purchased the patta land, my lord. This is my client concern, my lord. My client concern. It is not patta land, my lord.
Your clients?
Concern. Client not made any construction over and about the patta land, my lord. Rat land, my lord. My client concern, my lord. I said.
Rati land.
Yes, my lord. My client
Lord,
concern.
Lord,
Yes, my
on
lord.
14th of May, an application has been received by us, my lord. This is the copy of that application that
Even
has
my
been
lord,
made by
the Pradhan, as well as the private respondent
who is
18
the
to 10.
respondent hearing, my lord, against whom the allegation has been made, who made this application on 14th of May.
Even my
And
lord,
on that basis, we have started
Pradhan and as well
another
as the private respondent 18 to 20
My lord,
have
that
not
too- that
obtained
too-
any sanction plan. They
that too,
constructed.
they have raised
all
the
them,
entire
they have
construction on the Shali
sanction
plot.
plan, my lord.
And we have also issued another notice against them, my lord.
So you are also making construction
Yes,
on Sani
they
land.
have already completed.
Yes.
They have already
Maybe,
completed.
maybe.
all
My lord, I am not
about
concerned
to
of
be
that
completed,
point,
my
my
lord.
lord.
And
My
another
client
notice has
concern,
also
my
been
lord.
issued.
My client concerned if my
Entire
client has
the
the construction
has been initiated
about
out of
that not
private revenge.
patta land, my lord.
On 14th, they made,
Even, my
and
lord,
thereafter on 29th, they made.
even the Pradhan of the Gram Panchayat as well as the private respondent were 8 to
Raise your voice, sir. You are already doing some illegality. If the court wants, I will call your client here. Don't raise your voice.
my lord. The
By
Pradhan.
garb of a public interest litigation, you being the violators of law, you cannot come to us and say that this person is illegally moving. So you have to establish first, where do you reside, which plot you reside, and is it your own building, and whether you have sanction plan for the building.
Yes, my lord.
Yes, when will you come with that?
My lord, can you
How
make,
many
make it
petitions?
adjournment, my lord? My lord, make it adjournment. On the other hand, my lord, I am submitting before a lordship. On the other hand, my lord, I am submitting before a lordship the Pradhan as well as the private restaurant on 1820. They not obtain any sanction plan. They constructed the over and above the Shali and as well as without.
We shall look into that, what you have done.
This is not my construction. It is
The people of that locality made a complaint before the Pradhan that you have raised construction on Sali land.
Means he is the respondent here who has made this complaint. Borun Chok.
As a counter plus, he has made a representation.
I will produce the
As a
document.
counter
If
plus,
it
he
is
has
not
filed
satisfied before a lordship, then lordship will take step.
Thus, you cannot say a single word in favor of your client.
Lord, respondent number
By
20.
in their own hands,
Borun Chok.
okay, Panchayat Pradhan is there, I will go on constructing. If this is the way of thinking, then our entire state will be destroyed. If this is your thinking that my client can apply and start construction, and then you can come to court and say only one room has been constructed, my lord. Then you are in fact giving credit to the person for having done an illegal.
Lord,
All these persons, what do they think that we can do whatever?
In 2024, I told them where is the certificate. My lord, that is pending. My lord, I have annexed it. My lord, I annexed it. 2024, they applied for the sanction plan. They raise a complaint before that they are illegal construction. As a counter plus, they file this public interest litigation. My lord.
The application I
Father
have
of the
made over to
husband.
your lordship, my lord, that has been made by respondent number 20, sorry. I
Yes, what is
stand
your
corrected. my lord.
surname?
And the father of the husband made this construction since long back. How about that? If any person intend to erect a construction, then she or he obtained that's it.
Mousumi Haldar, he says, you said that he is a adjoining plot owner.
That's
We have asked you that your client is residing in any building or not?
yes, belong to
In a building.
building.
She must have
Of-
a sanction plan for that. We have asked you that you show us those plans also. So, Mr.
22 Lordship are appearing for the
আমার ইয়েটা করছে কালেক্ট সাবস্টিটিউট
item number 22 Lordship. I am appearing for the appellant Lordship. I am playing not this week Lordship.
Sir, I am following you.
Kindly take it up.
Mr.
Next
Bhatt is
week.
leading me in this matter.
Eh?
Mr. RM.
But I am appealing for respondents in
online.
this matter.
10th August.
Great.
Mr. Bach, come on 10th August.
Deeply obliged, Buller.
Yes, next.
Lord, I am for the petitioner, this matter, Madam.
Who's
That
your other side,
petition was-
Mr. Das?
The petition was admitted and direction upon the respondent to file opposition.
Filed opposition.
Pardon?
Opposition you have filed.
In a tribunal, we have filed, madam.
No.
That I have enclosed. In tribunal, we have filed.
Oh, I see.
Now the impugned order which is under challenge
Which opposition you are talking?
in this particular petition, they did
Any
not.
affidavit is required in this matter? You
No,
want to
no.
file any
All
opposition?
pleadings are I have enclosed.
All pleadings are complete in tribunal. Now, kindly
Yes.
order under challenge.
That's the petitioner submitted all the documents as per requirement of the respondents on 2019. 12/11/2019, page 76. Despite making all formalities, he did not get the settlement dues of her husband. Now he approached before this honorable tribunal.
You are appearing for whom, sir?
For Union of India, my lord, railways, for all respondents.
Now, Lordship, can you see? The tribunal in the first round of litigation direction upon the respondent to consider my claim.
পড়ে দেখুন
That is page number 181.
টেকনিক্যাল গ্রাউন্ড লিবার্টি দিয়েছে on technical ground ডিসমিস করেছে উইথ লিবার্টি
টার্গেটটা
File
ও তো চ্যালেঞ্জ করেছে সব
ওইসব অর্ডার ফর্ডার অ্যারেস্ট করে এটাই তো অর্ডারটা
Now, in the second round of litigation, my lord, the order dated 7/8/2025.
You have challenged.
Yes. I have challenged only on the ground, my lord. The tribunal has.
Please let us read. Please give us some time.
My lord.
বোর্ডে তুলে টেকনিক্যাল এই গ্রাউন্ডে দিয়ে লিবার্টি দিয়ে দিল।
ভাই সেটাই কিন্তু এখন আমরা কি করে ফাইন ফল করবো আর আমরা কি করে মেরিটই বা ঢুকবো কারণ ওই মেরিটে তো কোনো ইয়ে নেই ও যেগুলো করেছে সব তো ম্যারেজ
What is, why you are challenging this order?
I am challenging this order, Lordship, kindly paragraph 11, last two lines.
Yes. Last line, we also
We also find.
Yes.
We also find that the applicant number 1 in the original application has not specifically challenged the speaking order dated 14/12/2022 passed by the terminate persons of the order of this tribunal as such and such. This speaking order is in my favor. I am drawing a Lordship. This order is in my favor. They have.
Why didn't you join? Why didn't you challenge that order?
I did not challenge.
Oh, that was in your favor.
That is in my favor.
Then why did you file the contribution?
I filed this application because.
For challenging an order dated 14 December.
Yes, 2023.
2022.
2022 in my favor.
So you challenged which order?
2023 order I have challenged. Subsequent speaking order they have passed.
That
Now kindly see.
this is the 2nd of February 2023 is your challenged order.
The order which I have challenged also kindly come to page number 186.
We are not on that, Mr. Das. Tribunal has said some documents are not there, you file afresh.
Yes.
What is the wrong in this order?
Yes.
But wrong in this order is tribunal has said you did not challenge the speaking order of 2022.
No, that is your interpretation.
No, it's the last two line operative part.
Have you annexed the copy of 14 December 22?
Yes. That's
No, in the original application.
Yes, my lord.
Then why this statement was made?
That
We
is a
find applicant has neither annexed copy of the order
I
of
have
tribunal.
enclosed in my original application. Kindly come to page number.
In your presence, tribunal will say something which you say.
It was hard and reserved for judgment.
Okay?
It was hard and reserved for judgment. CAB. It was made on CAB. There the judgment has been pronounced. And tribunal has said you did not challenge the 2022 order. What is 2022 order? They have directed me to produce the legal aid certificate. I had produced in the year of 2019.
Where is the order which you challenged before the tribunal?
Yes.
Page
The speaking order which I have challenged before the tribunal.
2nd February 2023.
2nd February 2023.
Where is that?
Yes. Page number 152.
152.
52. Yes. That is, they have rejected my claim. My challenge in second round of litigation. Page 158.
Yeah.
52.
Justice Puri.
152 speaking order. That is the speaking order.
একটু ওয়েট করুন আপনি পাবেন সুযোগ কোনো অসুবিধা নেই 2nd February 2023.
Wait, let us go through it.
Yes. কোথায় আছে
From 170. From 176. Sorry, 76.
সালে স্পিকিং অর্ডারটা 22 সালে
এইগুলো আছে সাসপেন্ড বাই 14 অনেক অনেক
হ্যাঁ রিপ্লাইটা তো সব আছে তো রিপ্লাই দেখেই বলছি Okay.
Yes. But
Now-
where is your legal certificate?
Yes, kindly come to page 11. Got the legal heir certificate.
You have to obtain succession certificate.
Malad, they have asked for legal heir certificate.
No, no, you establish that you are the wife of the
Yes,
deceased.
malad, all the railway documents.
What
are-
document?
Yes, kindly see
No,
my
no, marriage certificate.
Malad, first, yeah, everything I have produced. Kindly come to page 71. These are railway documents. My husband has, because they have disputed these things, there is other marriage and so many things. Nothing is there.
So
In-
you
during
produce
the
your marriage certificate.
Yes,
You show
and-
it to us.
page 71.
71
Is a railway declaration form. My name is there.
Mr. Das, we are asking your proof of marriage. You show us the document,
Yes.
you take
Kindly
your.
come to page 76. I have produced all these documents. In my
None of these documents are, we are wanting, no, we are not. We are wanting your marriage certificate.
yes, marriage certificate.
Talk with your client whether you have the marriage certificate to establish you are the wife of the deceased.
Marriage certificate with
Show us the marriage certificate.
everything I have because
Everything you have not done in the order, it has been said that you have not done so.
marriage certificate I have got. I can
So
produce it
produce the marriage
by
certificate.
way of supplementary affidavit.
Supplementary.
Because original certificate I have to bring from my client.
Legal heir certificate, where is your legal heir?
Yes, kindly come to page 76. I have disclosed all the legal heir certificates.
76 legal heir certificate.
Kindly see, Malad,
Who issued?
76 is a letter issued by
76,
you.
also kindly see the enclosures. As per their
76 is a letter.
later, also kindly see the enclosure. Death certificate.
মনে করতে হবে যে আমি ওনার স্ত্রী নই।
That we also find that the applicant number such and such has not specifically challenged the speaking
that-
order dated
Yes.
14th December
I have challenged-
2022.
Yes, my
It is your grievances. You
my-
first stated it. It is the cause of your filing this present writ petition.
present
So
dispute.
where is that order 14th
Because
December
tribunal did not
2022?
deal with the challenge of my challenge of 2023
That's the
speaking
order.
order.
Show us that.
Show us this order.
Which order, Malad?
The last two lines order referred.
14th December
Yes,
2022.
yes, I am enclosing, Malad. Kindly come to page number 180. Last page 180B. 180 capital B. They did not reject my claim. Last paragraph, Lordship, can you see? 180 capital B. This is the letter dated 19th September 2022.
So railway administration can be able to settle the payment
Yes.
settlement dues on production of legal heir certificate
legal
from
heir
the competent authority
Competent authority.
as asked for.
And I have,
So you are claiming it is in your favor.
yes,
So there is no requirement to throw any challenge to this.
yes, Malad.
So where is that legal heir certificate?
Yes, that I have
Because as you said, legal heir certificate had already been produced.
what 2019.
Where is the legal heir certificate?
Yes, I
Any copy or anything?
yes. Legal heir
Or
certificate.
they have received the legal
They
heir
have received it,
certificate?
Malad. Kindly come to page 76.
So you
76
take
of-
this back.
They have received this certificate.
You
Malad.
file, so how you will be aggrieved if you approach the learned tribunal with a
Yes.
fresh original application and making this averment, how you will be aggrieved?
Malad, I have disclosed all the things before the Dandit tribunal. I have also disclosed the 2022 order.
No, no, show us, Mr. Das, you show us documents that will satisfy us.
Malad, I can produce the file supplementary affidavit disclosing the legal heir certificate and marriage certificate. Original certificate I should produce.
Now, so go to the tribunal, file a fresh
file a
letter
fresh
enclosing everything.
Then delay part will become, my lord. If your lordship.
Delay will be, you will also be there.
But
Delay কমানোর জন্য you will
problem
be-
is the tribunal are specifically directed to submit because this part of the order is totally wrong. I have to challenge the 2020.
We are giving you that here that while explaining the delay, you will be able to take the plea of pendency of the writ petition.
Yes, my lord. Lordship, I can, lordship,
That, only, ওইটুকুনি করতে।
kindly give liberty, my lord.
তোমার দিতে।
Or lordship, kindly,
you come,
if your
you are-
lordship give 1 day time, I can produce the marriage certificate and all certificate.
No,
All certificate I have deposited
Sir,
2019.
what do you
My
say?
lord, tribunal had already given him liberty to approach them with all these documents.
Can anything be done? Whether it is possible?
I mean,
No, my lord,
I did not get any settlement.
respondents have no intention to withhold all these things. But the thing is that they must also be safeguarded.
Right, right. Now, we are wanting to know the pension, anybody else has claimed this?
No,
No, my lord.
Nobody has claimed.
We dispute that a marriage itself is disputed marriage.
Marriage certificate is disputed.
No, marriage certificate, let him produce now.
If
So
he
far,
produces the marriage certificate,
and legal heir certificate.
legal heir certificate, if those two letters are produced, we will dispose it of
My lord.
sending it to you.
You were the general manager, I shall produce.
That railway will dispose it of, my lord. Practically, respondents itself themselves will dispose it of if they are satisfied with all these documents.
Who is the competent authority according to you to issue
Well,
legal heir
yes.
certificate? 1 minute. Who is the competent authority according to you to issue legal heir certificate?
We had written to district magistrate.
Huh?
District magistrate we had written. District magistrate Chinsura,
You
who
have to approach the district magistrate.
is legal heir certificate.
That I have produced the legal heir certificate.
Where? Issued by the district magistrate?
But they didn't turn up there.
First class executive
No, no.
No, district magistrate ke boleche.
76 I have produced.
Huh?
District magistrate, they are not taking into any cognizance. I have approached before the district magistrate.
District
but-
magistrate is the authority. From the local councillor or local authority, you have to take another certificate, one certificate, then it is to make an application before the DM, then the district magistrate will give another legal certificate based on that certificate.
DM had several correspondences with the applicant. They kindly produced something so that BDO had also sent them letter.
You challenge. Before the
No, challenge.
learned time.
I am not getting anything, man. Last fight, I'm fighting 2016. There is no dispute, but all the railway documents, my name, my husband had introduced my name.
দেখে নেবো।
Nobody has.
The respondents have also no ill intention.
Exactly, we understand that. We understand.
Yes, get obliged.
ওই 3 PM মানে হবে কি? তুমি কি দাও ওই তো বসে রয়েছে শুইছে না। ডেকে দাও কি আছে? কোনটা?
সব ব্রিফ নিয়ে আসছে 3টের সময় মামলা, তোরা আসছিস।
এটা কি?
চারটে কপি কেন? একটা ওনাদের দেবো?
All sides are here.
Yes, my lord. No, my lord, your losses on the last day was annoyed with me because illegible copies in the paper book. I have made the photocopies of the paper book, your losses. একটা copy.
এই কার্তিক, এখানে দেখো তো কোনটার পেছনে আমি একটা top of it means
That is office.
Well, kindly give me return, kindly, because there might be some marking on. Kindly. You know.
কত বড় বড়
$23 is the order impugn.
Exactly. তোর কাছে প্যাজিনেশন আছে 13 জনের অর্ডারটা কোন
Found enough, but page 190. একটা এভিডেভিড সার্ভিস দাও। You are taking us to the order impugn.
My lord, I wanted to place your losses on the last occasion also. The first order, my lord, of our division bench.
Where is that? Tell us.
That's at page your losses. 30. এখানে আছে নাকি? হ্যাঁ, এখানে দিয়েছি। My lord, we have given.
No, give us the number of the paper book.
No, your losses on the last occasion, that the very little letter was there in the order. Your losses could not read it properly. That's why.
Page 38.
Page number 10.
Which page you are saying, Mr.
10, page 10.
8.
10.
Page 10.
Look, if I place it, your losses will get the facts of it. And page 10 is a লম্বাটা বড় করে দিয়েছি তোমাকে। The petitioners in this petitioner candidates who appeared for recruitment as trained ticket collector, commercial clerk, inquiry cum reservation clerk, grade 3, pursuant to a notification issued by the Railway Recruitment Board on 3rd February 1997. Admit cards were issued to them. Written tests were held on different dates in Kolkata. The petitioners, having participated in the written test, expected their results to be published. However, they found that a fresh notification had been issued by the Railway Recruitment Board, indicating that the written test conducted earlier had been cancelled and that the board had decided to recruit persons in the aforesaid categories by starting the recruitment process afresh. Being agreed by the said decision of the Railway Recruitment Board to cancel the results of the written test in which they had participated, the petitioners preferred original application number of 1999. The tribunal, after hearing the parties, dismissed the original application on the basis of the order passed in OA 1999 and OA numbers 430 to 431 of 2000. In that order, the tribunal had held that it would be inappropriate and undesirable to quash the second notification, as that would unsettle the several persons and create administrative complications. The tribunal was of the view that the railways have a prerogative to cancel an examination for compelling reasons, though it had been held validly. The writ petition being such and such has been filed by several persons challenging the order passed in OA number 2000. Common orders were passed in both the petitions when they were admitted. We have heard the parties. It was the case of the railways that the records have been destroyed and therefore it was not possible to assist the court regarding the recruitment of the petitioners. On 18th August 2008, this court directed the railways to reconstruct the records from their computerized records in order to ascertain the marks obtained by the petitioners in the present case, as well as in WPCT number 2007. The court on 19th November 2008 in WPCT such and such 2007, along with WPCT such and the present writ petition of 2008 noted that an affidavit filed by the railways indicated that the soft copy preserving the answer scripts of a large number of candidates was available. The court therefore directed that a report should be prepared regarding the same. Accordingly, a joint report was prepared by the learned advocates appearing for the petitioners and the Union of India, and the same was filed in a court in a sealed cover. A further order was passed on 3rd December 2008, directing the lawyers representing the parties to inspect the records which were salvaged and to indicate the results of the candidates. Accordingly, a report was prepared and filed in court, indicating the result of 68 candidates which had been salvaged from the computers available. The report indicates the roll number of each candidate, serial number, code, total right answers, total wrong answers, total blank answers, total marks obtained, the number of answer sheets and file number. On 15th May 2013, this court had directed the respondents to place an affidavit on record indicating the number of vacancies available for the aforesaid posts. Accordingly, the respondents submitted an affidavit indicating the vacancies. Through an application made under the Right to Information Act, the petitioners in such and such obtained information regarding vacancies available. There is therefore no doubt that the vacancies are available. Moreover, centralized employment notice 3 of 2012 has been issued indicating vacancies for various posts in railways indicating the aforementioned posts. We found since there are several vacancies, it could be possible to accommodate all the petitioners without disturbing those who have already been appointed. Accordingly, the railways, after inspecting the records, have drawn up a list of those petitioners who have obtained more than the minimum qualifying marks in the written test held and which had later been cancelled by a notification by the railways. Though these details are mentioned in the letter dated 17th January 2014 from the Railway Recruitment Board to its counsel, Mr. Basu. The letter is taken on record and marked X for identification. The minimum qualifying marks mentioned in the aforesaid letter are on the basis of the selection process, which was to be conducted in the year 1997. The total marks allotted for the written examination were at 120 and 15% of the total marks to be allotted for the interview, that is 120 plus 18 marks. The minimum qualifying marks for SC, ST and OBC candidates in the written test is 24 and for the unreserved candidates is 36. In these circumstances, in our opinion, the present petition can be disposed of in the following manner. The Railway Recruitment Board, the respondents herein, will consider the marks obtained by the petitioner in the written examination held in 1997 pursuant to the recruitment notice dated 3rd February 1997 and appoint the petitioner in compliance with the railway recruitment rules of 1997. It is obvious that only those petitioners who obtain the minimum qualifying marks and above will be entitled for appointments after going an interview if necessary in accordance with the railway recruitment rules of 1997. We have been informed by Mr. Basu that there is no passing marks for the interview. The respondents will intimate to the petitioners the date of the interview by displaying the information on the website as well as by issuing a press notification sufficiently in advance and any event within 2 weeks from today. The interview, if necessary, must be held within 4 weeks from day to day. The petitioners will be communicated the result of such interview within 4 weeks thereafter. It is obvious that those petitioners who have obtained the minimum qualifying marks or above in terms of the Railway Recruitment Rules 1997 must be appointed against the vacancies which are already available. The appointment of the petitioners will be effected within 4 weeks from the communication, the result of interview to them. Therefore, on the basis of qualifying marks, we were called for interview, all of us, the present petitioners, and they were appointed in 2014 pursuant to this judgment, in the year 2014.
Then what is the problem?
Problem, your lordships, we are recruited in accordance with 1997. Kindly look at the advertisement. Then I tell you, I tell you lordship the facts. 1997 examination was held. On the basis of that written examination, we have been considered and appointed. This was cancelled by the railway board on the allegation from the Ajmer zone. Ajmer zone, my lord, there was some, my lord, difficulties suffered the board, my railway board. And as a result, they cancelled the pan-India examination. We questioned this. My lord, we questioned this when this was, my lord, there was report before the court that so far Calcutta zone is concerned, there was no foul play. But unfortunately, their case was that in the meantime, the railway recruitment board office, stand road, but there was devastating fire. According to them, all the record were destroyed by fire. But this was not correct, reply from the railway board. Ultimately, it was salvaged and found we have succeeded by getting the qualifying marks. So this, my lord, but in the meantime, what happened, dear lordships? Railway board moved an application in our original OA application 99 and 2000, asking they should be allowed to hold a fresh written test. The recruitment process was not cancelled, in the sense that the recruitment notification was not withdrawn. In the same recruitment notification 1997, they prayed for this permission in the learned tribunal, before the learned tribunal. Initially, there was an interim order, don't proceed. That was modified, giving them the permission. Permission, liberty was also given to the petitioners to apply for that, to appear in the re-examination. We didn't appear. We, stood, that we will fight it out because we have given the better examination. The records are lying with them. Now, ultimately,
the court's rider, it was said that minimum qualifying marks and those who will be entitled for appointment after undergoing an interview.
And that we have succeeded. And we
that
got,
you applied, that you participated.
yes, yes, interview held for us on the basis of the qualifying marks of 1997 exam.
Then what you are submitting now?
Now your losses up.
Said that I will not appear in the interview.
Next examination.
The next examination, fresh examination.
That you have not been asked to do.
No. Liberty was given to us also.
For?
To sit for the fresh written examination.
So you sat?
No.
None of you sat?
We contested in the original application. We lost. And then we came before this court. And this is the judgment of the division bench.
So very good. This judgment says that if you have the minimum qualifying marks, you can participate in the interview and thereafter you will be
But
guided.
in the meantime, what happened? On the basis of the fresh written examination, the railway recruitment board proceeded and railway appointed the persons.
But now they said that there are vacancies.
That's why we have been appointed. Now,
what is your case? What relief you want?
Now, my lord, we after our appointment, we filed, my lord, the fresh original application for, my lord, notional benefit. Because our recruitment is, your loss is 1997 recruitment process. That's your lordships. Kindly see the judgment. Judgment under appeal.
We ultimately given appointment in which year?
2014.
2014. So you are wanting it from 97.
Because my sought some substance, sum and substance of my submission.
98 সালে সিলেকশন টা 2002 থেকে অ্যাপয়েন্টমেন্ট হয়েছে, এটলিস্ট তাদের সাথে প্যারিটি আনে।
That's my lord.
Is there any direction towards conferment of benefit in the judgment which you are placing?
No, there's another judgment impugned before your lordships now.
Another judgment?
Because we filed fresh original application.
No, I am saying in this judgment of Justice Matre, is there any comment as to what
No.
whether
Because my lord, at that point we didn't get the appointment. Occasion didn't arise. Whether I will be appointed or not.
ইন্টারভিউটা দিয়ে পাস করব কিনা
So
Alright,
that
so,
question
so
is,
the issue is that you have been appointed 97, you should be getting the notional benefit from 97 till the date of your join.
that was rejected by the learned tribunal.
What was the reasoning of the
That's
sir?
it. Right. Look, page 191 of the দেখেন
Page
দেখেন
191.
191 এক এক করে যেটা যশোরে দেখতে চাইছেন সেটা আগে দেখা 191 of the paper book volume I think volume 2 Right.
Starts from
page 193 in fact 194 সব দেখাবো আস্তে আস্তে কেটে নেবো। Running page 194.
190, it starts from 199. Order of the tribunal.
Tribunal. Ordered,
In
matlab,
June 23.
193.
Volume 2.
Volume 2.
Volume 2, page 193.
193.
No, my lord, cause title or judgment dated 13th June 2023, page 194. My lord, first the learned tribunal quoted the order prayed for. Your losses will find the notional basis we prayed for in regard to promotional benefits, seniority, and other consequential benefits, as usual, my lord. Normally we pray for.
You are wanting promotional benefit on notional basis.
Exactly. With effect from the date of filing the original application, then your lordships during responded to give effect of consequent, including fixation of pay.
Competence. Consequential benefits in
The tribunal, then your lordships. For the sake of clarity, facts in this case are delineated and discussed herein under. The appellants applied for appearing in the written examination
No,
followed
not
by
required, Mr. Sanal. Let us go to the operative part.
operative.
Para 5.1.
5 point. The applicants appeared in the written examination for appointment to the post of inquiry cum reservation clerk, commercial clerk against employment notice dated 1997. After the conduct of written examination, it was decided to cancel the entire process and issue a fresh notification. My lord, here your lordship, I join an issue. Entire process was not cancelled. Notification remained. The Honorable High Court, after considering the facts and submissions in the matter, directed the respondents as follows. Then, my lord, this portion I have praised below, my lord, kindly consider. The respondents will intimate the petitioners by date of interview, displaying information on the website as well.
Required, you have already read.
Directions of the Honorable High Court were specific. Since the applicants had scored more than qualifying marks in the written examination held in 1997, they were to be offered appointment after interview, if necessary. Also, the applicants were to be offered appointment against vacancies available in 2024-2040. From the notification dated 96, it is clear that the selection process consists of written examination followed by an interview. This fact was noted by the Honorable High Court while passing the order in 2008 WPCT, in which the respondents were directed to grant appointment to the applicants after taking their interview, because the applicants admittedly did not face any interview. In fact, the results of the written examination was never declared. Thus, the selection process was not completed till the Honorable High Court passed the order directing the authorities to grant appointment to the applicants after taking their interview if necessary. The selection process which led to the appointment of the applicants cannot be considered to have been completed with the written examination. In the instant case, the process cannot be considered to have been completed only after the pre-appointment formalities like medical test, etc. were completed. The process was completed in 2014. Therefore, the claim of the applicants for granting them notional benefit in 1999 is not tenable. We also find merit in the contention of the respondents that since the applicants were appointed against vacancies existing at the time of their appointment, as per order of the Honorable High Court, their appointment cannot be given respective effect. We find of the above no infirmity in the decision of the respondents to grant service benefits to the applicant from their actual date of appointment. We also find no merit in the applicant's claim to rational benefits. Malad, there are two reasons given by the learned tribunal. First, Malad, I have been appointed 2014, therefore notional benefit cannot be given 1999. Malad, appointment given to us in 2014 is not a Malad, their fault attributable to us. We appeared in pursuance to your examination and ultimately found to have been succeed in the qualifying marks. We didn't face interview. Well, this is negative recording. Interview was not called upon.
It is saying that you have not participated in the interview?
No, that's kindly see your losses. How could it be? We participated in the interview in the sense, in our examination, interview was not held. They cancelled the examination.
No, Justice Matre's judgment was that you have to, if you
appear at the interview.
Now you did not appear in the
Yes. They say, Malad, tribunal holds I didn't interview so long. How could I interview? That's very incorrect.
Where is that line?
That's your lawsuits. Malad, at page 5.2, last three paragraphs, in which the respondent, in which the High Court judgment, they were directed to grant appointment to the applicants after taking their interview because the applicants admittedly did not face any interview. How could I face an interview? Because you didn't hold the interview.
একটু দেখি 2004 আমরা পেনশনে এলিজিবল হয়ে গেলাম।
দাদা না ওটা এখনই যাচ্ছিস কেন? তোর এখনই মালের দিকে নজর চলে গেছে। ওর মধ্যে কি হবে? বলতে পার না। আস্তে আস্তে চল। আগে পয়সা থেকে চলে গেছে। এই বোস মানিয়ে।
There was no requirement to participate in any further interview because you have challenged the notification.
No, they cancel notification, cancellation order. The cancellation of the first.
Where is the cancellation order? Show us.
The cancellation order, probably the first cancel. That your losses, that has been recorded in the High Court order, but that's not a part of. No, recorded.
Right. Notification. You applied everything. In the meantime, they cancelled.
No, written test held.
Written test.
Written test was cancelled.
Oh, I see. Written test was
notification not cancelled.
Entitled to appointment after undergoing an interview.
That they have done. Pursuant to the High Court order, that will be entitled for appointment after undergoing an interview. That interview you have done. What is the date of that interview?
That Malad is nowhere your losses. Obviously, after the High Court saw.
Positively after 2008?
Yes. Now, my junior says, Malad, that's there. I'm giving to you. Oh, Malad, there is a report in this.
First was the order by which the written test was cancelled. 97 notification.
Malad, that's probably not with the record. After we have annexed the division bench order.
You don't have that.
Was not placed advertisement neither in the original application nor before this Honorable High Court on admitted fact, that was
Cancelled.
cancelled.
That was cancelled.
All point of time it is
Cancelled prior to holding any interview.
Exactly.
Matlab that challenge, matlab there are two interview held, and after the cancellation, they proposed to hold interview to some candidates, but they did not take steps, matlab they did not appear in that interview. That was held. We sought for permission from the
That
judge.
is prior to High Court order.
Long, in 2004.
There are one batch appointed.
Acha, we will come to you. Let him finish. Yes.
Now, this is the
We're
judgment.
at page 197, tribunal's reason.
Tribunals. What I am assailing this order at page 197, your lordships, did not face, because that point occasion didn't arise of facing interview, because our written examination was cancelled.
Now, what is your answer to this? The next part, page 198.
Yes.
The selection process which led to the appointment of the applicants cannot be considered to have been completed with the written examination. In the instant case, the process can be considered to have been completed only after pre-appointment formalities like medical test or everything.
Yes, admittedly this has happened, my lord.
Process was completed in 2014.
By virtue of High Court order.
By dint of the High Court order or by virtue of the Honorable High Court order.
By the order which you are placing.
Exactly. Division. Now, but in the meantime, my lord, in 2003-4, they held another written test interview.
Now, what is your answer to this?
My lord, this
tribunal said that up to written examination it was done, thereafter it was stopped. It began, and you were in terms of the High Court order, which after beginning that process concluded in 2014.
Basis of
So
cancellation.
how you can claim notional benefit from 97? Process was not over.
process was
Not over.
that's your lordships. I'm
That is
answering.
one ground.
That's one ground.
And the second ground, which is the tribunal has said, that since the applicants were appointed existing at the time of their appointment, that is in 2014.
My lord, existing word was not in the judgment of the division bench. Word available. Now, their point, your lordships, I have been considered.
So naturally, availability will be on the date on which it was sought for.
My lord, I'm answering to that, your lordships, in my own humble way.
Now, are you meaning to say that prior to there were vacancies?
Exactly. That was eaten up by some other candidates. Because you, in the meantime, held the interview, but your action was caused by the Honorable Court.
You have agitated that before the High Court, Mr. Sharma.
Well, that the occasion didn't arise. How could I say it, your lordship?
Vacancies were called for, reports were filed.
Exactly. But notional benefits.
Place this order, interlocutory order, page
8 of your lordship broadsheets.
This situation was taken
Hmm.
note of by
This is order dated 15th May 2013. The issue involved in the present petitions is whether the petitioners are entitled to appear appointment to the post of clerk, commercial clerk, and ticket collector. It appears that first selection process was held in 1997-98 was cancelled, and a second selection process was held. The petitioner claimed they were successful candidates in the first selection process and were prejudicially affected by the cancellation of that recruitment process. After the second selection process was held in April 2000, the successful candidates have been selected and appointed to the aforesaid post. This was done consequent upon the orders being passed by the tribunal as well as by this court. However, there was no interim order directing that the post be kept vacant, or the appointments made pursuant to the second selection process would be subject to the result in this petition. In case we pass an order in the present petition which is favorable to the petitioners, those who are already selected would be prejudicially affected. In these circumstances, we think it would be necessary in the interim to ascertain whether there are any vacancies today in the post.
whether there are any vacancy
Today in the post.
Today in the appointment.
Exactly. My point would be, your lordships, that vacancies eaten up by the appointment of other candidate, it's not my fault.
That then you should have challenged this order.
Which,
Because this order says that they are not parties. How can I do that prayer, give that benefit to you? So consciously High Court says that is there any vacancy today? Because High Court wants to help you. Today the availability of vacancy is there, now you are. So the availability of the vacancy crystals down to the order of 15th May 2030.
but your losses, those vacancies has
Have
to,
been eaten away by others. You're right.
no, that's Malad, the advertised number.
Advertised vacancies have been filled up by somebody else. So court was of the observation that if you want any benefit pertaining to existence of vacancies in respect of said employment notification, then you have to implement them as parties.
Malad, I tell you losses, court didn't want that, we didn't.
You didn't challenge.
Malad, my submission would be that was not necessary in the sense, that was not necessary in the sense, in the final judgment your lordships will find that I have to be appointed in pursuance of the 97 recruitment notification and in accordance with law of rules of 1997.
Right.
Therefore, those subsequent vacancies relates to the 1997 notification.
That is why court said that you have not prayed for any order that keep those vacancies vacant. Make those vacancies subject to the result of the petition.
Malad, I didn't pray for that. Malad, what I'm praying for today is an equitable relief.
Yes, equitable relief. It was for you to challenge at that time because you were in want of employment. You are right that I am without any food in my stomach. First, I will say that first feed me. Unless I get that strength, it is like this compassionate appointment given. Now you say promotion, give me promotion.
Malad, I tell you losses. Now your losses seem to kindly look into this from this. That is my submission. Acceptable or not, Malad, up to your losses wisdom. Malad, as soon as I am appointed in connection with notification of 1997, whenever the vacancies arose or not, my appointment should be treated in accordance with that notification. Notification was never cancelled. Rules were
notification never cancelled after completion of written test. The said was cancelled. Entire selection process. Subsequently, court found that cancellation was not proper. Asked them take interview and give appointment. But against which vacancy?
Malad, suppose Malad, had I made them parties, Malad,
against which vacancy?
Malad, I request your losses to consider from this angle.
No, before that, Mr. Shanna, court was as a logjam position. Court said that you have not made them parties. How can I give you appointment in those vacancies pertaining to that selection process? So, for extension of the equitable relief, court said that, yes, Mr. Bhattacharya, are you having vacancies? He will come and say, yes, my lord, I have 40 vacancies. Court says you appoint me.
Now your losses. Kindly, my lord, consider from this angle. They have been appointed pursuant to tribunal's order by way of second examination.
Yes.
My lord, had I made them parties?
Second examination means?
Second, written examination and interview. My lord, my written examination was cancelled.
That is a separate selection.
Separate selection process.
Process is not different. I join an issue. Process is 1997. Kindly, my lord, consider this. Notification was not cancelled. Notification remained the same. I emanate.
But tribunal raised this issue whether the said selection process was concluded.
That
which was started in 1997.
I'll make submissions on this.
Concluded.
I make submissions on this. Threefold submissions will emanate from this. Can I say also that their selection process with the appointment recruitment process ended? Can anyone say before your lordships? Am I clear to your lordships?
Mr. Sharnal, this is a far-fetched argument. This is chance litigation. Let us get you are now saying I am appointed, you give me from 97. Just because court extends to you equitable relief, that does not empower you to come subsequently and say that you should have given me from that.
That's why
be fair to the court. Your clients have accepted the
My lord, I
appointment.
am not unfair to the court.
You are being
My
unfair
lord,
because without challenging that order, you are raising a point after 10 years that give me notional benefit from
my
97.
lord, that's why I'm saying, my lord, had I challenged even, your losses probably could not have given me any relief because those were appointed.
No, I gave relief. I said that you have been wronged. That is why I called the respondent. Come and tell me whether do you have any vacancy or not.
That
court wants to give relief to you.
That
Court gave that relief. Now you are being unfair to the court. That once you have given me that relief at that time, that should be construed as a vacancy of 97 exchange notification, and I should be given notional benefit.
my notional benefit, my lord, doesn't, my lord, believe, my lord, this is unfair to my humble submission. I am not unfair to the court. My lord, if I say this is unfairness on the part of the respondent.
No, because you were conscious. You were conscious that today, if I don't get vacancy, I will, even if the court is satisfied, court cannot give me
My lord,
appointment.
could your losses kindly visualize? I report I will place your losses. My learned junior
was the
report. Let's see. Page number 5.
Page 5 of, oh, this.
আরে দেখাচ্ছি দাঁড়া না বাবা উফ লজিকটা দেখ না
Page 5.
Page 5.
What is this?
This is the report before the honorable division bench.
That is at the time of issuing the order.
Final order, before the final order. Council. Kindly see. Today, got it your losses?
17 January 2014. Yes, today.
Today, Mr. Srimati Choitali Bhattacharya, Special Counsel, grade 2, handed over the separate list of applicants in relation to subject cases. The said list are undersigned. As it appears, the same do not contain the names of all the applicants of the these cases. Photocopies of the said list, 7 pages, are herewith sent herewith for information. As already intimated, the community-wise minimum qualification marks of the recruitment process through RBS at the material time was 30% of general category candidate and 20% for SC, ST, OBC. From the record submitted by the agency appears that the total marks in the written examination for category 15 for the post inquiry cum reservation clerk as well as for the post of commercial clerk collector number was 120. Therefore, the minimum qualifying marks of our scheduled caste OBC candidates are 120, that is 24, and the same for 30%, that is 36. The position of the applicants of the above list are furnished.
You are reserved candidates.
No, not all reserved candidates. Might be some of them reserved, not all.
Cut off mark.
Cut off. Well, your losses will find the position of the applicants. Your losses will find that in this list. Of the above list are furnished below. Then your losses will find or are qualified status. But the examination was cancelled. Then your losses will find up to 18. Almost 3, except 3 or 4, all were qualified. Far above the qualifying marks. It
Some
is
are not qualified.
Qualified, except
All
3.
of you are qualified.
I'm saying in this list. In this list.
Now, this appeal is in connection with any particular WPCT.
Yes, the subsequent rejection of original application that I am not entitled to notional benefit.
Yes.
It is important to note that as per the joint inspection report, the roll number such and such, serial number 9 is not. The roll number is also not. And then your losses, case number another. All are qualified. In this list, the second list, there are 2, 3, my lord.
All are qualified.
All are qualified.
Minimum qualification marks there. Now they
qualified for appearing in the interview.
Not only minimum qualified, we were far above of that. Now this examination was cancelled. And then second examination was held, not the process, under the same notification. And the appointments were made. We, my lord, were under the firm belief that I would succeed, and we contested the matter and ultimately succeed.
1997 written test was cancelled.
Basis of cancellation was cancelled by this honorable.
That is the first written test was cancelled.
By the authorities.
By the authorities.
And that was cancelled by the High Court. Because
cancellation has been cancelled.
Because appointments are directed to be given on the basis of this.
So it was cancelled. Now,
Otherwise, my lord, we
now
cannot get.
thereafter it was revived. Unless it was revived, it cannot get any life. to
So, my lord,
proceed.
under the same umbrella, there
So
are two,
when it was revived,
my lord, my submission, under the same umbrella, there are two selection examination. One, just because selection process ended fast, they will get benefit from that date under the same notification. And I was appointed last, therefore I will get from that. That's the notional benefit. I'm not asking for actual benefit. And the views of the my lord, tribunal as if that I didn't work. Vacancy. Reason is vacancy subsequent.
you are accommodated against future vacancy.
My lord, I accept future even. But that recruitment process is the same. And that I can say, my lord, available vacancies. My lord, my lord, kindly also consider your losses. এগুলো তো your losses will find page 2 of the broadsheet. আর অন্যদের অ্যাপয়েন্টমেন্ট কখন হয়েছে 2000 তাহলে তো 2002 তো হয়েছে ভ্যাকেন্সি তো ছিল 2002 হ্যাঁ তাদের কি now your losses will find তাই লেখা
appointed
সেটা সম্পূর্ণ হয়েছিল এবং সেটা 2010-এ conclude.
Mr. Chandal, the written test which was cancelled initially, that was 97 notification. Now then the fresh notification was issued for holding fresh written test.
fresh written test.
Show us that memo. Where is that memo? That
That's not my lord, part of the records because that's ended your losses.
If that has ended, then
No, ended in the sense, my lord, the process ended, appointments got, we got also appointment in 2014. That's why that's not the part of the examination. My lord, records are night now.
Selected and appointed to the appointed post.
My lord, one thing may I show to your losses?
then why you are saying that those already appointed, they were also under the same selection process?
Because the notification was not cancelled.
But this second selection process was started on the basis of a fresh notification.
Exactly.
So how can
Fresh
it
notification means your losses, but not in recruitment notification.
So that is what we want.
That's একটা কোথাও একটা ডকুমেন্টস আছে যে এক্সামিনেশনটা ফ্রেশ হলো না in terms of 1997 exam.
এই অর্ডারটার এগেইনস্টে আমরা কি করে যাব?
আচ্ছা my lord, your losses, kindly see the first judgment, probably that indication will be getting just
পার্টিসিপেট করতে পারো ওখানে রেফার করা
না না ফার্স্ট অর্ডারটা কবে
কতটা ব্যবহার তার কারণটা খুঁজতে হবে এই অর্ডার
এই 350 না বোর্ড যেটা
হ্যাঁ এখানে সব কটা
শুভরা তোমার কাছে আছে সেটা হচ্ছে
ভ্যাকেন্সিটা রাখতে পারলে না তুমি ভ্যাকেন্সি রাখতে পারলে না এবং তুমি সিলেকশন প্রসেস
my lord, I think your losses
subject to the result of this
না আমি বলে দিচ্ছি my lord, this will be evident from the affidavit of the railways.
Appointed against vacancies at
at the time of their appointment as per the order against the vacancy existing at the time of appointment cannot be given retrospective.
সব ডকুমেন্টস নেই
যারা এই 2010-এ 2000-এ অ্যাপয়েন্ট হয়েছে তারা এসে চলে আসবে আমি কেন
The selection process which led to the appointment of the applicant cannot be considered to have been completed. In the instant case, the process can be considered to have been completed only after pre-appointment formalities in 2020. Therefore, the claim for the appointment until from 99 is not tenable. It is not acceptable. The second is acceptable. One is the letter by which the written test was cancelled, and the second letter by which the new persons were appointed.
New persons were called for fresh written exam.
Yes, that was that letter.
That's true, your lordship, but
এই তো 1 নম্বর পাতাটা পড়ো না। A difference above the appointment details of panel 26 candidates for the category 15 employment notification 97 as intimated by STO VT letter such and such is into
আরে নেই, তুই বল নেই, ওটা আমাদের মে আই draw your lordship's attention.
এই 2 নম্বর পাতাটা কিন্তু
আমি ওটাও আসছি। মে আই draw your lordship's attention, kindly
we go against the observations of the order which you have just placed before us. Available?
I will show, my lord. How they have treated me, I will show. There are further proceedings.
No, we will not allow you to go on for days. We have.
No, I will not. I will.
Point. Either you show us the documents or satisfy us our question. Then we will go to other question. Otherwise, not.
Do two things. First, I am showing your lordship their affidavit, what they say, and then the other documents.
No, you are not being able to answer our question. We have put you two questions. That the first order, it was said 29th of the
29/1/2014.
দেখি না জোসে কি বলছে নাকি
page 9.
Page 9.
This order has not been challenged by page 9 of the broadsheet.
After the second phase was held in April.
After the second selection process, first line. After the second selection process was held in April 2000, the successful candidates have been selected and appointed.
To the aforesaid post.
The aforesaid post. This was done consequent upon orders being passed by the tribunal as well as well. However, there was an interim order directing that there was no interim order directing that the post be kept vacant or the appointments made pursuant to second selection process would be subject to the result of.
I do not join any issue factually. I do not join. These are correct.
Then
rather, we initially got an interim order that was modified, giving liberty to Railway Board to hold fresh written examination. I'm saying that. But even then, my lord, I'm asking before your lordship the relief I prayed for the reasons I just cited before your lordship. It's not that I'm disputing these facts. Admittedly, I didn't. Because I stood
not not fact, the decision.
That's it, my lord, that's a fact.
Considering this court asks, you produce the data regarding the existing vacancy as on today.
Well, I say your lordship.
I can accommodate them in that vacancy.
I will show your lordships even. If I'm not wrong, those vacancies are available.
No, that you cannot re-argue here, Mr. Sharma.
Well, kindly existing vacancies never mentioned. Available vacancies.
That is your interpretation.
Well, language also that. Your lordship, kindly look at the judgment.
If the interpretation is that, why will the court unnecessarily say that you have not made them parties no interim order that their appointment will be subject to result.
But
These are confirmed findings. We cannot go beyond this, Mr.
But
Shah.
I'm not also asking you go beyond that because I didn't question their appointments either.
You are not question because those vacancies filled up. You are saying
Exactly.
give me notional benefit from 97. For giving a notional benefit, there must be an existing vacancy on that particular date.
That's join an issue not.
No, you cannot. You could have joined the issue at that juncture. You could have said that I pertain to that interview process. You have to. Situation has given appointment to fresh incumbents. Make their appointment subject to the result of my writ petition.
I didn't do that. Now, second year losses when the court ordered subject to interview. How could I make that prayer unless I become successful in the interview and appointed? After appointment, I could make a prayer for notional benefit. You look, I participate and then I can do it. Otherwise, my cause of action didn't arise.
Your written test permission would not have come had there been no available vacancies also. Even going to the furthest office. This was after the
Your lordship often pass having been satisfied with the facts in the subsequent vacancies also. It's not that. Suppose vacancies were not available.
No, court has not created vacancies.
I'm never say the supernumerary, even court never create. But your lordship often direct supernumerary
Right.
post.
Yes, we directed.
Now your lordship.
But not with a retrospective effect.
The appointment never given a notional benefit is a prospective effect.
Notional has to be
senior হয়ে যাবে।
No, not become similar. I'm not a senior.
For promotion also. Promotional and notional.
Promotional, all monetary benefit. And they have given me to an extent already from earlier date. I have been given from pension from 2004 under the old pensions. I'll show that your losses. But since your losses certain point on law raising, I'm answering to that. I'll show that your losses. I've given pension from 2004 for one-time benefit. 2004 under the old rules.
Old rules means which rules?
Rules of 1973. I'll show you losses.
How does that improve your case?
Therefore, they are also treating me notional, but other benefits. Kindly your losses do that.
Oh, when you are getting pension, that also you want to take advantage and say that means that there was vacancy.
Otherwise, but this is an order passed by the authority and on
Mr. Sanal, anything else you have to show us?
Kindly, factually I have to show others. Kindly কোনটা আসছে সবই এর তো annex আছে Now your losses kindly consider this. There are page 289 your lordships 289 300 and 298 289 289 first.
When was your interview pursuant to Justice Mathre's order?
First half of 2014.
August.
First half of the year 2014.
After 29 January.
After that order.
After that order.
Obviously after that.
And March appointment.
And in the month of March 2014 we have been appointed.
August 2014 was the written date. August 2014.
No, after January. Appointment in March.
Appointment, your lordship will get the appointment letter at page 43.
No, interview.
Date in between January and March.
Of
2014.
January and March.
Between January and
And you were given appointment in 2014 itself.
March 2014. Page 4. Well, that will be your lordships will be get an appointment letter. That will be getting your lordship page 43 to 74 of the paper.
All appointment letter.
Now page 289.
Page 289. Yes, page 2.
Now kindly see your lordships. This is notification dated 31st October 2023, 289 and 290.
What is this notification?
And kindly consider your lordships. These are the names of the petitioners also here.
Yes.
In terms of the railway boards,
Yeah.
letter dated 10th March 2023 containing Department of Public and PWAs for coverage under Railway Service Pension Rules 1993 in place of National Pension System. The following railway employee commercial department of Sialda division who were recruited against the post vacancies advertised notified for recruitment on or before 12th December 2023, but they had joined railway service on or after 1st January 2004 and submitted their option before 31st August 2023 for switching over from NPS to OPS have been found eligible for coverage under the railway service pension rules as per order provisions contained in, and this has approval of the competent authority. Therefore, my lord, we have been given exercise of option and we have been given pension under the old rules. Then your losses will find we exercised option and then they accepted the option. The next page, your lordships. Well, the applicants before your lordships are 9, 10, 11, 14, 15, 16, 17 in this list. 9, 10, 11, 14, 15, 16, 17.
Yes.
Then your lordship the paragraph. The provision under the said rules envisages for one-time option to be covered under Railway Service Pension Rules 1993, and the option thus exercised is treated as final. So we have exercised option according to their notification, they accepted and that become final.
Alright.
The eligible staff shall be required to subscribe to the General Provident Fund, and necessary adjustment of employee contribution will be made to GPF account of the individual staff as admissible.
Yes.
Then your losses consider page 298. This order of 31st October 2023 and this is an order of 10th March 2023.
Yes.
A copy of the Department of Pension and Pension Welfare dated 3rd March 2023 and is enclosed herewith for your compliance and guidance. These instructions shall apply mutatis mutandis on the railways also. Civil Service Pension Rules 1970 correspondent to Railway Service
have guided your pensionary benefit procedure, you should be treated as benefit was given from that, it should be construed that I am entitled to the benefit under the from 1997 on.
This is one, and this, I tell you, lords, after given this, your lordships, the language, your lordships. Given this, your lordships, your lordships will find the subject. See the parent order, that would be better, 300. ঠিক আছে হ্যাঁ দিচ্ছি আচ্ছা ওটা কভার আচ্ছা মানে দিস one page is missing of this
page 300
এটা আমাকে একটা দেখো আমারও আছে এটা কাইন্ডলি সি না দিলাম this is the parent order same malad one page is missing
পেনশন দেবে কি করে
coverage under central civil service rules in place of national pension scheme of those central government employees who were recruited against post vacancies advertised and notified for recruitment on or before 2003. That's why I'm repeatedly saying, my lord, I was recruited against advertisement of 1997. Then your losses, kindly see your losses. The undersigned is direct to say the consequent on introduction of national pension scheme in by Ministry of Finance dated 22nd December 2003. All government servants appointed on or after 1st January 2004 to this post under central government service are mandatorily covered under the national pension scheme. I have appointed, admittedly 2004 after. I am covered by national pension scheme normally. The Central Service Rules 1972 and other connected rules were also amended accordingly. Subsequently, the Department of Pension and Pension Welfare, in consultation with the Department of Personnel and Training and Department of Expenditure such and such, in the light of the various representations, references, and decisions of the Honorable High Courts, issued notification dated 17th February 2020 giving one-time option to central government employees who were declared successful for recruitment in the results declared on or after.
We got the occasion to read this this notification.
So, my lord,
but analogy, whether this analogy can be done from 1st January 2024, the central government introduced a new pension scheme. And thereafter, subsequently, by issuing notification, they stated that who was recruited in connection with a notification issued before a particular date, say December 2023, but recruited after 1/1/2024, they shall be given a chance to exercise option, whether they will be governed under new scheme or under old scheme. That facility has been given to them.
We also.
So whether this analogy can be given.
No, this benefit has been given to us also.
Yes.
Then your losses, how could be given benefit to that? Logic is your losses. If the process is before, kindly read between the lines your losses. If the process before 2003, appointment may be 2004, even then they will be given benefit. This is notional. This is the language your losses. Paragraph 4 your losses, kindly come to that. Kindly see the paragraph 4. Because it doesn't affect anyone. I am not taking away anybody's benefit. Kindly see paragraph 4 your lordships. The matter has been examined in consultation with Department of Financial Service, Department of Personnel, such and such, in the light of various representations and decision of the courts in this regard. It has now been decided that in all cases where the central government civil employee has been appointed against a posted vacancy, which was advertised and notified for recruitment and appointment prior to the date of notification of National Pension Scheme in 2003, and is covered under the National Pension Scheme on joining service on or after 2004, may be given a one-time option to be covered under the 1972 pension. We have been extended also that. Yes. And we got it. Now, because of pendency of this matter, they have stayed it.
Yes, Mr. Sir. Any other point you want to say?
Therefore, my submissions, your losses, notional benefit doesn't depend upon the actual working. I will judge, my lord, 2-3 judgment I will show it to your losses and record.
Yes. With judgment, Mr. Sharma.
No, সেটা আমার কাছে আছে। Promotion is also not. Judge সাহেবের judgment-টা দাও। না, দেখছি। কোনটা আছে? না, ও সিনিয়র সুব্রতদের। এটা সুপ্রিম কোর্টে এটা না, আগে তুমি জজ সাহেব এটা দাও। না, মানে এইটা মানে 1996 দুটো কপি আছে তো? I find your lordship's judgment also on this point sitting singly. No, singly.
The condonation of qualifying service.
No,
Deficiency.
giving notional benefit. Now I can show thousands of that. Now your losses passed the judgment, even appointment giving supernumerary post in primary teachers in 2020 and 2019. That's now those persons are claiming benefit from the date of appointment, from the date of recruitment, but because delayed, they kept it pending. Those persons have been given benefit, notional. There are judgments, your lordships. CB philosophies.
Era 35.
Paragraph 35.
Yes, sir.
You can listen. The earlier writ petition filed by the appellant was allowed on 13th May 2010. The division bench of the High Court has directed to recast the seniority amongst the 7 shortlisted candidates. The applicant was one of them. The challenge to the said order by 3 affected candidates remained unsuccessful when SLP was dismissed by this court on 8 October 2010. The SLP was filed by the candidates who are granted the benefit of moderation of marks. Once the direction of the division bench attained finality, the appellant was entitled to seniority as per the select list to be revised as per the merit of the candidates. In terms of Rule 6.2, the seniority is to be determined by the serial order in which the name appeared in the appointment order. The argument of the learned counsel appearing for the respondent number 5 that the appellant was not appointed by the same appointment order. Therefore, appellant cannot claim seniority is not tenable. The appellant was entitled to be appointed along with the other 3 candidates. But because of the action of the High Court in adopting moderation marks, the appellant was excluded from appointment. The exclusion of the appellant from the appointment was on account of an illegal act by the High Court, which has been so found by the judgment dated 13 September 2010. Since select list has to be revised, the appellant would be deemed to be part of the appointment along with other candidates in the same select list. As the actual date of appointment was 24th February 2011, the appellant cannot actually be treated to be appointed on 30th 3rd 2009, but is entitled to notional appointment from the date and consequential seniority.
Yes.
Now, this is my case before lawsuit. এটা কোনটা বলো? আছে কপি?
এটা কপি আছে। বিমান বিহারী ঠাকুর এখানে এই প্যারাগ্রাফটি দেখে
তুই পড়েছিস?
আমি জাস্ট এখন দেখাচ্ছি আমাকে এটা।
Now this is your lordships 2019 sorry SCC online Calcutta 9103 of the High Court of our division bench. Page এই তো এই পেজের কি মাথা না থাকে বুঝি না।
এই তো আছে 9103
অনলাইন তো 9103 मतलब paragraph 9.
Why Justice Bhattacharya's name has gone before Justice
I don't know, my lord. Probably the direction of Justice Dotto.
Can we accept Mr.
Paragraph 9, kindly consider this. In paragraph 9, 10 and 11 of Ram Nagen Chaudhary, we observed as follows. However, it cannot be lost sight that if the petitioner had been favored with an order of appointment within 2 months of his selection for appointment on the post of constable, he could have served the government in excess of the period for which he had actually served and therefore may have qualified for pension. The reasons for which appointment of the petitioner was delayed till almost a year after his selection is not too clear from the materials on record. It is because of such reason that we are minded to grant the petitioner limited relief to the extent that the matter must be reconsidered at the level of the additional chief secretary and home secretary to the government to ascertain whether the appointment of the petitioner was delayed for any fault attributable to be. In the event, no fault can be attributed to the petitioner, and it is found that the official formalities consumed unreasonably long time to be complied with, which by exercise of due diligence could have been avoided, the additional chief secretary as a special case and without creating any precedent allow the prayer for the petitioner.
It must be realized by one.
It must be realized by one that all that allow it is pension and the other retirement benefits, and retired employee looks up to sustenance in the winter years of his life. If such the provision part 4 of the contract to be given life, but ultimately we'll be getting certain notional benefit after fixation of notional fixation, we'll getting certain benefits in pension and your losses certain area, current. Still in service, except one probably retired. Petitioner number 1 in the meantime has retired. So this is the benefit we will be entitled to. There is no fault of ours, on our part.
Yes.
Judge Saheber একটা judgment আছে division bench এ।
Your losses has also a judgment. I will hand up with a copy to my learned friend in the tomorrow morning I'll give. With a copy to my learned. On the same principles. The notional benefit doesn't depend upon the creation of.
This argument will be that these vacancies do not pertain to the.
Yes, that is one. But so far this judgment is concerned, well, I am not now dealing with. So far the other point is concerned, well, this is a third division bench, well, they are trying their luck. The first division bench they filed on can, what was not the case before in the original application. The second division bench they are filed can 2.
For what? Can was filed for what?
That pensionary benefit they tried to
subsequent
development bring on record. Can 1.
These documents which Mr.
Yes. Can 2, my lord.
Now, Mr. Bhattacharya, what is your answer to this? That suppose you are giving the benefit of a particular scheme of 1993, treating me to be a contestant in a selection process.
And that benefit, though declared, it has kept in abeyance. We have an opposition to this. My point is they are making out a third case which was not pleaded in the original application. They cannot make out a third case and argue before your lordship to get benefit. And
in the original application they have
no.
Original application all benefits.
When they did not born in the cadre, they are not entitled to that. That's the Supreme Court judgment. On the date when they born in the cadre, they are entitled to get benefit. Prior to that,
না পুরো ডিফারেন্ট কেস
তাহলে আমরা ফ্যাকচুয়ালি ডিস্টিংগুইশ করছি কতজন বলেছি
judgment with other division. Yes. আজকেই হয়ে
erased by them.
And I am reading that portion of the
One thing that they cannot be held responsible for the delay caused by you.
Delay is not attributable to the
Your
respondent.
cancellation was not proper. It has been judicially proved.
And my lord, before that, I will show my lord, what is their representation, from which the cause of action arose, what they claimed.
At that time, this was not in
But
the
your
list.
lordship kindly look to their representation.
Before I am born, how can I say you make me the king?
No, after born, what they prayed.
They were appointed in 2014.
And thereafter they made representation.
Naturally, because they are in the sequel of proceedings, they are trying to make out their case that exercise.
And what prayed in their representation? What is their prayer in the representation?
Show us that.
Yes.
Then show us that representation. Which are you showing?
Prayer to ছিল কি?
For your mistakes, they have
No,
been.
this is
serving
not
in the
mistake.
court
That was
of-
not held by your lordship's court. That there is a mistake.
Naturally, because fresh selection, that is why the court granted relief.
That is why, my lord, the court wanted to give them some relief so that they
Not
are.
some. We are saying you are the employer. I am a lamb. I am fighting with a liar. My appointment is not confirmed.
Your lordship kindly.
For your negligence, we have been kept at part. And now you are saying did not take that point there. If I am not born, how can I take the point? In any litigation, Mr. Bhattacharya, you cannot anticipate what is going to be happen.
This is not a question of anticipation, my lord. This is a.
Naturally, because they did not knew that they would at all get appointment.
But because when they initially moved, that is not before you. They have not.
Page 75, Mr. Bhattacharya.
Yes.
What you are showing us?
Representation after the High Court's order, appointment after 2 years. But your lordship has seen they have got appointment in my lord,
2014.
2014 March. And this representation is dated, my lord, 2016, August 2016.
After about 2 years.
After about 2 years.
And see the Malad prayer, page 76, last paragraph. What we have prayed.
May I place the
Not
representation?
the entire, you can come under the circumstances. Page 70.
Your lordship kindly, before the paragraph 7.
Yes.
Now it is asked that the notional benefits, promotional benefits, and subsequent benefits should have been given to the undersigned since 29 January 2014. They are claiming that is from the date of judgment because their rights had crystallized on the basis of a judgment dated 29 January.
Because they are claiming 29 January 14. They have stated that we are claiming from 29 January 14.
Now, subsequent, now your lordship, that is
date of the judgment.
Date of the judgment.
Today's argument is give me from
Completely
97.
different. Completely different.
But what was the necessity for
And
giving
your
this
lordship kindly,
representation?
under these circumstances, your lordship also under it is paid before your good
So they are wanting from the date of the judgment.
29 January 2014.
That is not the argument.
That is
Their
not. They
argument is
are asking
97.
for 1997. notional benefit.
আমার original application period টা পড়াও না।
Where is your prayer, Mr. Shannan?
My lord, your lordship, this was written
Because
by
this is not telling with what you have said.
now I tell your lordship, my lord, just your lordships.
ওই period টা পড়াও।
An original way from this, after filing this representation, they move before the tribunal. What was the prayer in the way?
Page 32 টা পড়াও।
That is very relevant. That I have, that they have not brought in record. I have filed this by way of supplementary affidavit. This is before your lord.
That way.
That way is here, my lord. What that way has not been annexed here. What was initially they filed after making the representation. Before and
That way is not here. Order of that way is under challenge.
yes, my lord. And after that, my lord, your lordship kindly take my supplementary affidavit. Supplementary affidavit.
এই দাও না সাপ্লিমেন্টারি এভিডেন্স কোথায় আছে?
Page 32 তুই পড়াও বলছে ওই
অপোজিশন সাপ্লিমেন্টারি আছে।
Satisfy your lordship to that part.
Way to direct the cancer.
ওয়ে তো আছে।
না 18 না 99 এর ওয়েট
99 এর
এটা তো তখন জন্মাইনি তো আমি কি করে করব? আমি চাকরি করব জানছি।
This is the first way.
what was it? That was challenged before your lordship's court. In that way, arising out of that way, my lord Justice Matre passed this order.
No, no, we are wanting to know where is the way from which this order arises.
that we
আমাদের ওয়েটা পড়ো
2018.
74 75
পেজটা বলো
84
84
84 থেকে আমাদের স্টার্ট
Yes. P6 84.
গর্বটা পড়ো 84 থেকে পিরিয়ডটা দেখ from the date of filing of the original application 99 থেকে
Yes, that
হ্যাঁ তাই তো চেয়েছি আর রিজেকশন অর্ডারটা দেখো
153 দেখো রিজেকশন
page 108, their prayer really short for original application. They have become prudent and they are praying manner that should be given.
Page 108.
108.
রিজেকশন অর্ডারটা জানো
From the date of filing of the application, that means you filed in 2018.
Yes.
Huh?
Yes.
continuous cause of action
because questioning the rejection order.
They did not take part.
Promotional basis on, sir. Oh.
এই রিজেকশনটা বার করো
This is a completely third case not made out.
তোমার দেখো
কোথায় গেল রিটিন নোটস
All right. Anything else, Mr.
And I want to show, rely on the judgment.
Show us that, give us that judgment born in the cadre.
Yes. Just.
Yes.
আরেকটা কথা 766. এটা just chapter number.
বলছিলাম
Paragraph I'm sure.
Huh?
Paragraph 18.
Paragraph
I shall
18.
realize some of the paragraph. Your lordship kindly first peruse the paragraph 18.
Yes.
It is no longer res intriga that a promotion is effective from the date it is granted and not from the date when a vacancy occurs on the subject post or when the post itself is created. No doubt a right to be considered for promotion has been treated by courts not just as a statutory right but as a fundamental right. At the same time, there is no fundamental right to promotion itself. In this context, we may profitably cite a recent
It's not
decision.
applicable, Mr. Bhattacharya.
I-
Pertaining to promotion.
Well, I'm coming to the, I'm coming to the notional part. I mean, paragraph 19. Well, one part I am relying on. Well, we are also of the view that Malad has got it.
Yes, that is
We are
Uttaranchal.
also of the view that no retrospective promotion or seniority can be granted from a date when the employee has not even born in the cadre so as to adversely affect the direct recruit appointed validly in the meantime, as decided by this court. And the paragraph 38 next, this court has consistently held that no retrospective promotion can be granted, nor can be seniority be given on the retrospective basis from a date when an employee has not even born in the cadre, practically when this would adversely affect the direct recruits who have been appointed validly in the meantime. Now, my lord, paragraph 21, the quoted portion, my lord, 34, middle portion. These cannot be allowed as no retrospective effect can be given to the order of the appointment order under the rules, nor in such contention reasonable to normal parlance. This was the view taken by this court in Jagdish Chandra Patnaik versus State of Odisha. Now, your lordship kindly peruse.
All right. If the learned advocates appearing for on on 7th August.
But I have, so far, I have not advanced my argument on the basis I have recorded in my, your lordship has put me some question, I have tried to give answer to this, madam. And I have not dealt with the judgment cited by my learned friend, madam. That your lordship kindly give me liberty.
We were keeping, we will pass our orders on that date. If you want to point out something, point out.
That day, madam, your lordship give me liberty to.
No further hearing, Mr.
But unless, madam, my learned friend has argued 2 days.
The two judgments we have put questions to him. We have put questions to him.
Another judgment I will show to your lordship, my lord, that what was not pleaded, he cannot make a third case.
That you have argued.
That's the judgment also, my lord, recent judgment.
Please give us the judgment tomorrow.
Well, the citation I can give here and now. 11. I wanted to place the case in my own way. That your lordship has not allowed. That is why.
No, it is not that I am not allowed, we are not allowing it. We are in judicial review, whether the question is correct or not.
For that matter, I have to show your lordship how the writ petitioners has proceeded and come to this honorable court. What is their conduct? What was the case original?
No,
case?
that we have seen because we have put questions to Mr. Sannal on this point.
Yes.
From our questions, you must have.
Yes, I have.
So everything is indisputed. Facts are not disputed. Facts are not disputed.
No, facts are.
Facts are not disputed, but this situation occurred when subsequently when they were appointed, further memos they collected, they wanted to form.
They have
strengthen their case.
By the second can, they have relied the 26 candidates who were appointed. To that they got benefit. They did not choose to appear before that, they choose to continue with the litigation. They choose to continue with the litigation.
What happened?
But the can to file before your lordship's court, they are taking a point that prior to this their interview, the 26 candidate were appointed. But your lordship has seen that to that manner the tribunal granted leave to give appointment, and that has been approved by your lordship's court subsequently. They choose not to appear in that interview. They choose to continue with the proceeding. That I wanted to show your lordship.
That I admitted.
They
That I
continue.
admitted.
Had they appeared with
No,
this,
that is an admitted fact. They
Yes.
did not appear.
just a minute, the third case and relevant paragraph.
Which site? Give us the
That I
site.
could be praised, my lord. I fought it rightly. That I am okay in the first.
Okay, that issue decided.
I didn't dispute anything.
This is a judge.
But
This
I
is the judgment of my lord.
Now
That I'm right.
whether you will get notional benefit or not.
Yes, Mr. Bhattacharya, which judgment you are saying?
This is my lord, Allahabad University, my lord, reported in my lord. Civil no, it SCC the report knowledge was but I shall show this one as SCC reporting on the next date, because otherwise your lordship will. I shall supply this judgment to you and the citation to my learned friend Malan on the next date, Malan, when your lordship hear the matter.
Next day we are passing our orders.
Malan, and also before that, we will rely this judgment to hand over to your lordship.
Yes, if you want to rely on some other judgment, give it over. And if we have any queries,
Yes, sir.
we will, on the for orders date, we will tell you.
May I, in that event, this is not, reporting part I am not giving, I have got it from.
Right, share one copy with them and give to our court officer, and Mr. Sannal if wants to give any judgment. লিখেছো? As for orders, অমুক দিন রেখে দেবে। Yes, এইটা কি? এটাকে বেঁধে আমার কাছে পাঠিয়ে দিন।
জাজমেন্টটা দেখাচ্ছে সুবিধাকে দিয়ে দিও। সুবিধাকে একটু
বলে দিও না।
ছবি তুলে
না, এটা SCC না হলে তোরা পাবি না, আমি তো এখান থেকে বার করেছি না।
কোথা থেকে বার করে? SCC তো আছে, বার করে নেবো। এটা ফার্স্ট পেজটা তোল তো।
এটা ফার্স্ট পেজটা তো
হ্যাঁ।
পেয়ে যায়।
কোন সব দিনকাল বদলে গেছে সুকুমার দা।